Welcome to the Board of Selectmen's meeting on Wednesday, June 6th, 2018 at 6 p.m. The purpose for tonight's meeting is to interview for town council. Let's start off with the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. There are no treasury warrants and no minutes for approval this evening. We're here strictly for town council interviews. There was a screening committee that conducted interviews on April 18th and April 19th, and their recommendations of 5 firms were brought to us, and we're going to be doing 3 interviews this evening and 2 interviews on the 12th of June. And first is Mead, Tellerman, and Costa. They're here with us, and if they could come step forward, and Mayor Mead is here this evening, and you can introduce everybody for us if you could.
I could. Thank you, Mr. Chair, and my name is Lisa Mead, and I'm one of the partners in the firm, and with me this evening is one of my other partners, Adam Costa, and one of our senior colleagues, Kate Federoff, who heads up our labor department. And Mr. Chair, you can tell me how you'd like to proceed, and we'll go from there.
Mr. McCoy, how are you?
Sir, I apologize. Welcome to the town of Wilmington with all kinds of traffic. You're gonna find that out.
It means it's successful, right?
There you go. Let me introduce to you the members of the board, if I could. It's Greg Bendel.
Good evening.
Mike McCoy. Myself, Kevin Kyra. Ed Loud. And Jonathan Eaton. And I'm sure you've met our town manager, Jeff Howe. I guess, why don't we start off with some opening remarks and tell us a little bit about the firm and however you want to lead those remarks.
Okay.
For all 3 of you, if you want to speak, or
I think
just yourself.
we'll each say a little bit of something so you can get a flavor of who we are, but why don't I give kind of a broad overview of our firm. As the chair has kindly reported that at one time I was mayor of the city of Newburyport, and I had a city solicitor who did office hours for me, and I really liked the way those legal services were provided. And so when I left the city hall and I became city solicitor in Somerville, again, it was kind of an in-house kind of thing, and I met my original partner, Mark Bobrowski, and he was a land use lawyer, and we got together with the intention of creating a law firm which provided a different kind of town council services to municipalities. We didn't want to be a firm where your attorney kind of floated in when there was an emergency and then it cost everybody a lot of money to resolve a problem. Rather, we wanted to restore the council part of town council and be a part of the organization and kind of help you make decisions along the way so you would understand what the ramifications were or the risks were of those decisions, and try to prevent litigation and help propose a way to do things that would prevent litigation. And so Mark and I originally in 2004 created the firm of Blattman, Bobrowski, and Mead. Blattman was his spouse who did real estate law. And we did that for a long time. And in 2007, Jay Tallerman joined us. Jay comes from originally from Copeland and Page, and then worked on his own for a while, and we brought him over because he too had that same idea about how really you wanted to be a partner with your municipality, your client that you represented. 2 years ago, Mark and Betty Ann are they're older than Jay and I. They would be upset if I said that out loud, but they are, and they are more on the retirement end of things, and Adam was with us for a very long time, since 2003, 2004, something like that. And so we amicably decided to split up, but we continue obviously to provide municipal services. We currently represent 14 communities as town council, and we are essentially, even though we're special counsel in 2 other communities, we generally do their town council work. So we represent 16 communities essentially, aside from our other special town council needs. We have 9 lawyers, and we have 2 offices, one in Newburyport and one in Millis. And I'm going to turn it over to Adam to add a little bit more about how we provide these different services, namely through our fee structure.
So thank you all again for having us. We had an opportunity to meet with your screening committee. We appreciated that, got a bit of a flavor of your community, and having researched it a bit before that part of the interview process, and obviously through the back and forth that occurred at that meeting. So as Lisa said, our firm is 9 attorneys strong. We are a growing firm. We brought on a couple of attorneys within the past year. We have 16 communities. We think that based upon the number of communities we have, the number of attorneys we presently have is just about right. If we continue to pick up communities, we'll certainly grow the firm by bringing on additional attorneys. We pride ourselves on the fact that we are a medium-sized firm. We think it's important that you get the one-on-one communication, that you have that single point of contact that we propose in our response to your RFP, and that we're able to put the face time in your community. That's something that I think differentiates us from the other firms that provide municipal counsel services. We've heard that sort of feedback time and time again. We hear it early in the interview process. Communities that have gone out to bid for legal services often do so because they're dissatisfied with their current counsel, and in those instances, we've heard feedback that, well, we see a different person every time we call on counsel to be present for a meeting. We don't feel like we get the responsiveness that we expect. We don't get answers to questions promptly, and that doesn't put us in the position to get ahead of problems, to tackle them before they arise. So we pride ourselves on being able to do that. We pride ourselves on availability. You heard we have 2 different offices. We have an office in Millis and an office in Newburyport. But the nature of today's practice is such that we're on the road almost more than we're in the office, and that's a good thing. It means that we can be available to you. We, of course, all have cell phones, and so we're available 24/7 anyways. We're working on Saturdays and Sundays. We're working late into the evenings because that's just a part of municipal council work. We're at zoning board meetings and planning board meetings and Board of Selectmen meetings. We also pride ourselves in our fee structure. That's something, again, that I think differentiates us a bit from other firms that provide municipal counsel. And I don't want to reiterate in great detail everything that's already in the package of information you've got from us, but you'll see if you look at it that we have essentially given you options. We have 3 different fee structures that we propose to our communities, and different communities fit with different fee structures, and you have a choice. We have the more traditional structure, which is that we bill on an hourly basis. The fee we propose is $190 an hour, and you can keep track of those hours, and you can choose to use them as you will. There are communities that we represent that appreciate that sort of a structure. Again, it's more traditional, and if you feel you can keep control over legal costs better that way, then certainly that's something we're willing to do. We also have a complete flat fee proposal, and that's something that, again, is sort of unique. I know that there are a couple of other firms that are offering it, but we've offered it for a number of years now. It's attracted many municipalities to us because they can plan ahead. They know that municipal counsel services, all in, not only the day-to-day, but litigation expenses, will total the amount that we're budgeting for here in our response to your RFP. There are very few exceptions, and certainly we can discuss those if you've got questions, but we provided a detailed list over a page and a half of our proposal as to what's included, and you'll see that it is relatively all-inclusive. We then have sort of a middle ground. It's not an hourly proposal, it's not a flat fee proposal, it's a partial flat fee that includes essentially all the day-to-day and the week-to-week and the month-to-month, except litigation. So if you're a community that doesn't have a whole lot of litigation or feels that you can control the litigation, well, then the litigation would be outside of that flat fee. It would be a partial flat fee that covers the day-to-day but doesn't cover the litigation. So those are the 3 different options that we have, and you can choose from those options and decide what's best for your community. With that, I won't talk any longer. I'll let Kate speak a little bit about our labor practice because I know that's something that you've asked for as well.
Hi, I'm Kate Federoff, and am I on here?
Yeah.
Okay. I'm Kate Federoff, and I, on top of being just a generalist, I fulfill all the labor and employment needs for our clients in this firm. And I'm relatively new to the firm. I joined the firm about 1.5 years ago. Prior to that, I was the senior assistant solicitor in Brockton. And I come at it from the same perspective as Lisa. In Brockton, it's in-house positions, so unlike some of the other municipal firms, it's really more of a collaborative approach, an approach to try to get ahead of problems rather than react to problems once they've already arisen. So on the labor and employment side, I have experience in collective bargaining. I did all the bargaining for the city both public safety and all the smaller city-side unions. I have civil service experience, having appeared before the commission on terminations, bypasses, MCAT experience, general employment matters like investigations into employee conduct, or even it can go to more of a practical level rather than a legal level in terms of operations and how our departments working well together and most effectively. Sometimes it's helpful to have just outside legal advice in those situations. So, and translating that to towns, from my perspective, has been pretty seamless. So many of our towns require labor and employment experience, and what my policy is try to get ahead of the problem. So before, when you have a suspicion even, or you just need a framework for how to approach a certain situation, my phone is always there, and that's my approach, and it's been successful to date. So that's that.
You told our screening committee that there was some litigation, environmental litigation in Ashland. I wonder if you could elaborate a little bit on that for us.
Sure. I don't think I said there was environmental litigation in Ashland. I said that there's a Superfund site. So I know you have the Olin Superfund site. And the question, I believe, from the committee at the time was, do we have any experience with a Superfund site similar to the Olin? So in Ashland, they have the Nyanza Superfund site. It's all capped now. When we started in Ashland, they were still negotiating the final documents and the final closure between DEP and EPA. And so I did the negotiation of those documents on behalf of the town, which ended up, first they were and I, forgive me because I don't remember the title of them from the EPA's perspective, they turned over to activity and use limitation documents. So initially they were going to record the EPA, and EPA was going to be responsible for the follow-up and the cleanup and the maintenance, and then DEP took it over. And so they became activity and use limitations. And the town had sewer and water easements throughout the property where the Superfund site was, and then the cap, in and around the cap. And so we had to negotiate the town's access to those items. It's a little bit different. I mean, the Olin site obviously is an ongoing issue with the town. I know that they were in here last fall, the EPA was in here last fall to report to the board what the status of the cleanup and remediation was. I understand that Olin has still got a long way to go. And I know that the town, the Surface Transportation Board is looking at citing your regional, that regional transportation rail system there, rail yard, if it were. And that your next opportunity, I think, based upon what I've read, to comment or to have some involvement related to that would be the environmental statement, impact statement that would be required under the first Surface Transportation Board for that proposal. So you're a little ahead of where we came into Ashland, but certainly we are familiar with all of those activities and the various boards involved.
I noticed what you had mentioned before about jumping ahead and getting ahead of the game. You have office hours that you're going to provide to town hall, so you'll have set times that you'll be here. I noticed that in here, which is different than what we've had in the past.
Right, so one of the parts of this, and I played a little bit of short on this in my introduction. One of the things we do is have office hours. So we would have 2 days a month, or maybe more depending on what the need is, but at least 2 days a month where we would be in town hall. And so we would be accessible to the town manager, to department heads, to chairs of boards, to the Board of Selectmen, whoever needed us. So let me give you an example. I just came from the town of Ashland, and I spend every single Wednesday in the town of Ashland. I meet with the town manager, the assistant town manager, department heads. We address upcoming planning board meetings or zoning board meetings. you know, the building inspector will come in and ask questions about issues that he has or enforcement requests that he has. We help, you know, they do strategic planning with regards to economic development that we participate in. I review contracts at the time that I'm there. So I see that happening in most of my communities, and so that's the whole purpose behind being here. That's not to say that we're not available and accessible at all other times, because we are. But that is the idea, is that people become comfortable with us, so they're not afraid to pick up the phone because, you know, somebody's going to ring up a legal bill. We want them to ask us questions so that we can see what they're doing and help give advice along the way.
And there are some things that are just better done face-to-face. I mean, as I mentioned before, there's a lot that you can do these days electronically or by cell phone or otherwise. But there's a lot that can be accomplished face-to-face. And so I likewise have communities in which I'm lead counsel. I perform office hours there. And the way that it works in one of my communities is there are structured office hours. And so about 2 weeks in advance, there's an invitation that's sent out to all members of staff, municipal boards and commissions and committees, and they have an opportunity to sign up for a 20-minute slot. I'm usually there for 4 to 6 hours, depending upon the issues that happen to be going on in that community at the time. And they sign up for slots, and it gives me the opportunity to sit down face to face. And the sorts of things that would be much more difficult, you know, if we're dealing with issues that are before the Zoning Board of Appeals. I was out there a couple of weeks ago, and they've got a complicated property transaction, and there were a couple of different plans, full-size plans that needed to be reviewed, and better orient me to the site so I could understand the documents I were drafting. That was a lot easier to do in person, face-to-face, than it would have been trying to do over the telephone.
I think it's important to build those relationships too, so that folks aren't hesitant to call town council, especially from the labor and employment context too, because you're dealing with sensitive issues. So once you've already established that relationship with these department heads, you become really a part of the team as opposed to the hired outside, you know, counsel, the hired gun. So it's a different perspective and a feeling with the client and the lawyer.
How much experience does your firm have in front of the appellate tax board?
I'll let Adam address that. He's one of our lead counsel for the appellate tax board.
So we do a fair amount of work in front of the appellate tax board. You'll notice one aspect of our fee proposal is that what we say, whether it's the full fee or the partial flat fee, is that we don't generally get involved, and therefore it's not within our fee structure, in the day-to-day appellate tax, the day-to-day appellate tax board abatement appeals, because the average appeal is really within the four corners of your assessor's job description. Doesn't really require much legal expertise. If you're dealing with traditional residential properties with the sales comparison approach being used, you find 2 or 3 comparables, and your assessor goes and the taxpayer goes, and they duke it out for 20 or 30 minutes, and that's all there is to it. Where we do get involved is in the far more complicated transactions, the 10, 15, 20, $25 million sites where there's a difference of $5 to $10 million between what the taxpayer believes it should be assessed and what the town's assessing it at. We get involved in those cases. Those cases don't rely as much on the sales approach. They rely more on the income capitalization approach and other approaches to value. So it's a more complicated analysis that occurs. You also tend to have experts involved in those cases. So while you might rely upon your assessor, you're probably going to be advised to bring on an outside consultant, somebody who can perform, a true appraiser who can perform an appraisal of the property, because certainly the taxpayer is going to have that sort of an appraiser as well. So we get involved with those with some frequency. I would say I'm in front of the appellate tax board several times in the course of a year on those sorts of cases.
So is Jay.
And our partner Jay Tellerman does a fair amount of work there as well.
Okay. Attorney Fyodorov, did I pronounce that correctly?
Fedorov, yeah.
Fedorov, I apologize.
It's okay.
Are you the only labor and employment attorney at the firm?
No, Mike Kennefic in actually the Millis office also does labor and employment.
Okay, what were your and his billables last year?
On labor and employment matters? Good
what-
grief, I don't
what
know.
was-
Most of our clients are flat fee, so.
Okay, because
No,
my-
we're
my-
proposing 100, so our fee proposal is $190 an hour if you were
Which
to
is
do.
why I asked the question.
Yeah, so the fee proposal is $190 an hour if you do the hourly, but the labor labor is always billed on an hourly basis. So it's $190 an hour.
My question was last year, how much was billed for, or how many hours were put into labor and employment?
How many hours are put into labor? Boy, what do you think a percentage of your job, like your
I'd
percentage of your
say
hours?
25%?
Of your time is devoted to labor and employment and the
Yeah.
other attorney?
And
Mike, probably the same.
yeah,
Yeah,
I would say
I'd say.
so.
Okay. And if most of your, do you track the hours that you're putting in even on flat fee cases?
So I can answer that. So you're gonna get a bill no matter what you choose.
Yep.
That shows every single thing that we do and how much time we spend on it. So it doesn't matter, we bill the same, so you're gonna see it. You're gonna see the phone calls, you're gonna see the emails. We keep a very detailed bill, you're gonna see it on a monthly basis, just like every client that we have. I will tell you, we don't bill for like paralegal time, we don't bill for administrative time, we don't bill for copying. You know, you would get, if we had to do, you know, a FedEx, or, you know, we had to do a deposition, you know, things like that, transcripts, you're gonna pay for that. But all other accessory items you don't pay for,
Okay, so
regardless.
if all of your work were hourly, and I realize this requires a bit of guesstimation, but last year, if 25% of your work was put into labor and employment, about how many of billable or billable eligible hours do you think you put in?
Oh, Jesus. I don't,
500.
Let's see.
500?
Yeah, 500.
Okay,
Yeah.
what's your case management software?
Our case management software?
Yeah,
We use e-ability primarily.
For billing.
for billing,
For
but
billing.
case management software, do you use anything else?
No, we don't have case management software.
Okay.
Mr. Chair,
Yes.
if I may. Thank you. A couple quick questions. I'm glad to hear that I touched upon a couple of things, the collective bargaining, the environmental. I wonder if you could tell me, of the 9 lawyers that you have on staff, how many are familiar with the zoning issues? And I noticed here, as a follow-up question, that you've done some work for zoning work for the town of Tewksbury. If you could just give us an example,
Sure.
without
So
specifics, obviously.
So when Mark and I first started the firm, we actually did nothing but land use law.
Okay.
And so Jay and myself and Adam are huge backgrounds on land use law. And so that would be all zoning and planning. Everybody is able to do it, but certainly I would say that Jay and Adam and I have the most experience in that area. We do recodifications, zoning board hearings, litigation, land use, land court work. We're very familiar with it. We do a lot of, on the other side of it, what's beneficial, we do some private work too. It's probably 10% of our overall business, I would say, is private work. Obviously not in the towns that we're doing municipal work. But I would say, you know, between, and particularly Adam and Jay, like at the HAC, you know, how many cases a year do you have at the HAC?
A fair number. I mean, 40B isn't what it was at one time prior to the Great Recession, so the HAC work isn't as much as it was 10 years ago. Our background is primarily, or at least prior to 2007, 2008, 2009, was land use. I think it's a good place to start for municipal law, because municipalities, I'd say in most municipalities, about a third of your issues are land use related some way, whether it's conservation, zoning, planning, or in some instances your select board. So we handle a fair amount of zoning cases. I handle about, I'd say, between a third and half of the firm's litigation, and much of that is land use litigation. About half of my litigation's in the land court, and by its very nature, therefore, it's involving land use matters. And much of what I do in Superior Court and even in District Court has some land use component to it. So we've done special counsel work in Tewksbury for years. I think Lisa has also had a case there a number of years ago, a piggery, right? And so we were involved, I can think as far back as 2006, 2007. I was doing some affordable housing work, representing the Zoning Board of Appeals in their reviews of Chapter 40B. They had one after another in Tewksbury, and we did reviews of those, not only assisting the board pursuant to 4453G accounts, where the applicant provides funds that are then used for the board to engage counsel. We were engaged as special counsel, but then we subsequently did work on the back end once those projects got fully permitted and there were regulatory agreements to review and deed riders and such on the affordable housing side. We got involved in that process as well.
I just looked at the chair. I forgot about the piggery. So Wilmington was involved in that because it's right on the Wilmington line. So that was a number of years ago where we did a site assignment in Tewksbury for that piggery.
So Tewksbury's not one of your actual 16 clients, but
No.
you've done some work. So how many of those other clients, like Tewksbury, do you have outside the 16?
At any given time, I would say we'd have 10 or less, depending on what the issue, and they're short-term one-offs. You know, Adam is doing a cell tower issue in the town of Hamilton right now. You know, Jay did a issue regarding a Muslim cemetery in Dudley. So they're one-offs. They last for a couple of months and then they're gone. So people need special counsel for a particular matter. I'm doing a comprehensive permit issue in Natick right now, because I did, a while ago, I did a bunch of comprehensive permits in Natick, and they've got another one, and they called me back, and they want me to do it. So, you know,
And I guess another comparable that I'd be interested in is your client, is the town of Burlington. Perhaps you could just elaborate a little bit about your work with them. How long have you been with them?
sure. So we're not currently doing any work for Burlington, but what we did was, I know John Petron, he was the town manager who hired me in Ashland, who hired the firm in Ashland originally in 2007. And so John went from Ashland to Burlington. The law has now been changed, but there was an issue related to the payment of recoupment of health insurance benefits from retirees from other communities, where the retiree left the community and then you had to collect the money from the other communities, and the other communities were supposed to pay you. Some communities did that, some communities didn't. So we worked on behalf of the town of Burlington and actually on behalf of the town of Chelmsford, and together, and we brought actions against the communities that weren't paying. Shortly after that, the legislation changed as part of the Municipal Modernization Act, and now that's gone away. But that's what we did for the town of Burlington.
Great.
And I did one regulatory agreement enforcement item for the town of Burlington as well.
Great, thank you.
Yes.
First of all, I want to apologize to my colleagues in being late. I was a few minutes late, but I know time was important
It's fine.
for you folks to start at 6, and I apologize to everybody. And what I'm wondering is, does Newburyport have an open meeting like Town of Wilmington?
No, so Newburyport is a city, so it has a mayor and a city council. But almost all of our other towns have an open town meeting, except for somebody has an elected town meeting,
Representative.
a representative town meeting.
Jay's.
But almost all of ours have open town meeting.
Okay, all right, very good. And the other thing, I want to just touch upon it. I thought there was 8, but you say you have 9 attorneys and you have 16 communities and you do a little bit more other communities from time to time. You think just under 2 lawyers, do you think one attorney handling 2 towns, you think that is sufficient?
Oh, yes, absolutely. We can absolutely make that happen. We do it regularly. I will tell you, if it looks like we're about ready to go over the top, so to speak, we'll advertise and hire somebody in the appropriate instance. But I think if you were to call any of our communities, they would all tell you that we are there like that, and we are responsive, and we do quality work for them. So I don't have an issue at all with the attention that we give the communities that we are lead counsel in. And we double up. So I'm lead, let's say I've proposed to be lead counsel in the town of Wilmington if we're successful in getting this job. And Adam would be the backup. And the idea to have 2 people is so you always have somebody to talk to. So if I'm not available, Adam's going to be available, but I'm always the lead, so you don't have to chase people down. But we also do things to help make things more efficient. So, for example, you'll see in our proposal, we have a standard form set of contracts that I will prepare for the town of Wilmington. I look at your bylaws and your charter and make sure that they're appropriate for the town of Wilmington and any policies that you might have. That prevents us from having to renegotiate every single contract every time you put something out to bid. But that's a waste of my time, it's a waste of your money and somebody else's. Plus, it doesn't necessarily always get you the most protection. If you use our form contracts, when you go out to bid, I know they protect the town of Wilmington, and I'm not going to negotiate away those protections for the town. So we do things like that to help save time and efforts. But we don't have a problem covering our communities. I think if you were to call other town managers, other members of the Board of Selectmen, they would give you the same answer.
I think if I could add, I think it's also important to remember that just because we're proposing a lead counsel, that's really for accountability and for convenience. So the idea is that if you've got a lead counsel, that's who you should see almost every time for your office hours. That's who you should be able to pick up the phone and get a call right back from if the phone's not answered. it doesn't mean that that person, we don't operate in silos in our firm. In fact, we have this repeated conversation amongst ourselves, amongst the partners, about making every effort to avoid ever operating in silos. We operate as a firm. So just because you've got a lead counsel, if I'm your lead counsel, if Lisa's your lead counsel, Lisa's not doing all of your work. Just because I'm second doesn't mean I'm doing a portion of your work. It means that the work is being spread amongst the firm. We've got individuals who focus on certain areas of the law more than others. We've got an attorney in our office who handles a fair amount of the contract work. If we get contracts, those contracts might be reviewed by her. We have an attorney in our firm who handles a fair amount of the open meeting law violations when we receive them. That individual would get the open meeting law violations and would address those. So the idea is that you have one person you can contact at any one time. You'll get a call back, you'll get an answer. But that's not the sole individual in the firm that is doing work for the town of Wilmington.
Yeah, like, Wilmington's a little unique, and I say it in not a great way and not in a bad way. We have the Olin Chemical, we have New England Transrail. These are two things that we've been fighting for decades. Right. And we had to shut down, we lost several of our wells because of that. Right. And that's ongoing, and it's a battle that we've been fighting for decades. And I know you touched upon a little bit, just can you elaborate a little bit more of the expertise you would have when it deals with the EPA, the federal government, the DEP? And this is a Superfund site. This is what we're talking, it's some serious.
Right, it's very serious, and let's take that as an example, because I think in that instance, that's a team approach, right? So you don't want just one attorney working on that. You want a couple of people doing different things on it to make sure that we cover you appropriately. But also, you want an expert, you want your LSP, so I'm sure you've had some kind of consultant work on behalf of the town. I understand from reading some materials from the board that the EPA has offered that when you do your response to the environmental impact statement for the Surface Transportation Board, that perhaps there's grants out there that the town can get to hire a consultant on behalf of the town to review the environmental impact statement and how you can respond to it. But so we would work with the town and the town's experts and become immersed in that. And so I would do that, as well as who there would be other attorneys in our firm who would also hop on top of that matter and make sure that we knew the best ways to protect the town and talk to the town about what they needed to have happen in that regard. I can give you an example right now. We have a pretty significant piece of litigation in a town that I'm lead counsel in. And I've been involved in this project since the time I started representing the town. So in this instance, it would be like 2005. And there's a long history of it. But I have two other members of the firm that are working with me on this project because it's big. You want somebody to keep track of different portions of it to make sure that it's coordinated and nothing's falling through the cracks. And so we would spend the same amount of effort and resources on the Olin site to see if there's anything else that the town can do to speed up the recovery, the remediation, and close out the site and whatever other impacts are having in the surrounding neighborhoods. So, we would, obviously we haven't become immersed in it yet, but I have read some preliminary work. I've read the minutes from your last Board of Selectmen meeting where EPA came and reported to you on it, along with some of the reports in the earlier 2004s on it. So I became a little more familiar with it when we came back after the last interview that we had, and we would certainly jump right into it.
The community you're talking about, is it similar to where the DEP basically handed it's a Superfund site, and basically the federal government took it over? Is that
well, that would
similar?
be the example I was just giving you was not a Superfund site. Okay. It was just actually was a landfill.
Oh, okay.
So Ashland had a community organization. Mm-hmm. It had obviously the town. It had EPA. It had DEP. The Superfund sites are handled very similarly. The problem now is that the resources have been so cut, both the DEP and the EPA, it's taking them longer to close these Superfund sites out and to stay on top of them. So, I'm a big believer in the squeaky wheel gets the grease, right? And so I think that we'd start to find those areas where the town could be squeakier.
Right. Thank you, Mr. Chairman. Well said.
A lot of my colleagues have asked a lot of the questions, and I was real glad to hear that you have a lot of Board of Appeals and Planning Board experience. And you mentioned Mark Bobrowski.
Yes.
He actually wrote a land use book, so
yeah,
the Bible.
The handbook.
The book.
He's got a new edition coming.
He's in front of the town right now, the Board of Appeals, on a case that's controversial for the townspeople. If you guys were town council, how would you handle that case against him?
Very aggressively. I mean, we represent the town. I actually have other towns that he's appearing now before.
He appears in front of a lot of towns.
Right. And we look, the town is our client. I guess the good news is we kind of know Mark's moves, right? So, you know, we will represent the town aggressively, without question about it.
It's a small world.
Yeah.
And the land use community, I mean, there are a handful of attorneys that practice land use and zoning law in Massachusetts. You tend to see the same ones over and over again. So we're collegial with them. I'll shake Mark's hand outside the meeting room before I'm about to go in, but when we're in that meeting room, we represent our client.
The reason why I asked that question is because the town in 2020 is going to be below the minimum for affordable housing.
Right.
And we suspect, and we're probably going to see some more 40Bs. My experiences was on the Board of Appeals. I was on the Board of Appeals for 14 years. So that's a concern that I have, that we have representation that protects the town
So,
going forward.
you know, it's interesting. So I read about that. You're at 10% now.
Yep.
You currently have an age-restricted project under your inclusionary
Right.
zoning that's before you. So you've got some tools that you're trying to stay ahead of the game, so to speak. So I mentioned the Natick example earlier. I was asked about our special counsel work. Natick is above 10% also. But what they've started to do is, as part of their housing production plan, and just generally, is they've started to try to pick some places where they know they would do essentially a good comprehensive permit. And so the reason I'm there is they had a pretty large one proposed, 10 stories, 120 units, rental. And it didn't really fit in with their recent comprehensive plan they had for that area, and they're over 10%. But they don't want to entirely say no to this. This is a rental development. So they did a calculation to understand what it would take to stay above 10% at 2020. How many of the units would they actually need out of this development to stay above 10%? And could they mold the development to meet their needs and also meet their master plan and comprehensive plan? So instead of absolutely saying no, we brought the developer in and said, okay, look, we're not going to say no. We're going to let you come before the board. But this is what we want the project to look like. We want the project to be 6 stories. We want it to be 60 units. And at 60 units, I'm still going to be ahead in 2020. I'm going to be over my 10%. So I'm still going to be in control. And so they've started to use 40B as a tool, a planning tool, to mold the projects they want, knowing that they're going to have to give variances and things like that. They would give waivers instead. But mold the projects they want in order to stay ahead of the SHI in 2020. You know, Cambridge does that. Cambridge is way over their 10%, as you can imagine. And so people, what they do is they try to pick developers to come in and do projects using a 40B tool and not having to use variances and special permits, and mold projects the way they want them and require affordable units, obviously, as part of the 40B to stay ahead of their SHI. And so I think it's a tool that we could talk to the town about if it's something that they were interested in that, with that goal in mind.
I think the town needs to develop more affordable housing. We're actually in front of the board, well, is being discussed right now as an inclusionary bylaw for that. Do you have experience in helping towns develop an inclusionary bylaw?
Both Adam and I have drafted inclusionary bylaws. Jay has drafted inclusionary bylaws. It's not something we're unfamiliar with at all.
And you said you're familiar with 40B. On the Board of Appeals, there was one project that the town denied but got appealed, and it got built. It's Regency Place, and it's one of the first ones. And
right.
But I can see others coming down the pipeline with some significant pieces of parcel of land available in town for either redevelopment or development.
Right.
So you as a town council will help the town from the very beginning of a 40B project?
Oh, sure. Absolutely.
What?
That's the best time to be in on it. You don't want to be in the last meeting to draft the decision.
Well,
You
that's the way this town did it.
Well,
When
right.
I was on the Board of Appeals.
You want to be in the beginning.
Okay.
Right.
What about a controversial site? I'm going to throw it out there, the Detox Center, which Mark is involved in.
Yeah.
Would you be involved with the Board of Appeals from the very beginning?
So yes.
Because Mark's there.
Yes, so here's the thing, this is one of the reasons we practice the way we practice, right? You have volunteers who sit on the zoning board and the planning board, right? And applicants come in, and look, you've got big parcels of land with people who have a lot of money and businesses, right? So they're gonna come in with a huge team of experts, right? So you've got the architect and the engineer and the lawyer and the economist, and they come in and they present all this stuff to these volunteers, and they all may be professionals too, but they all have other jobs to do, right? So why shouldn't your boards have their own support? They should have their own support. You should make the applicants pay for a review engineer, make the applicants pay for a review architect, have your lawyer sitting with you to run the project and not let the applicants run the hearings.
And we've done this in a number of our communities lately. So 40B was all the rage back in the early 2000s through the mid 2000s, and the recession hit. Heard nothing of 40B. I was out 3-4 nights a week on 40B hearings back in 2008. Overnight, it went from 4 nights a week to 0 nights a week on 40B work. It's coming back around again. Our communities are seeing it, and so I can tell you, in the past 6 months, I have been to multiple meetings. Some of them have been informal meetings where municipalities have been approached, boards of selectmen have been approached with potential friendly 40Bs, possibly unfriendly 40Bs, and I've been asked to come in and sit with the Board of Selectmen, sit with the Zoning Board of Appeals to provide just primers on the comprehensive permit law, what 40B is all about, because they don't know anything about it. In one community, they hadn't had a 40B project. So what's it all about? So we had those informal meetings, public meetings, open meetings, but informal, just discussing the law generally, to put them in a position where they had the information they needed to make the decision. Do we want to endorse this as a LIP, as a friendly 40B project? Or do we want to make the developer do it the hard way and go the more traditional route? What are the pros, what are the cons? Same thing with the Zoning Board of Appeals. Once it gets to us, what's the process? What's the ZBA's role? And it's unlike anything they're used to. It's unlike special permits. It's unlike variances. It's unlike administrative appeals. The standard's different. The deference that your board is used to when it gets to court, 85-90% of the time winning if it opts to deny a variance or a special permit because it's entitled to deference. You don't get that deference in the 40B context. So the ZBA has to understand that it's up against it when it comes to these sorts of projects, because on appeal to the HAC, the odds are reversed. 85-90% of the time it's the developer that wins. So what does that mean in terms of how the process gets shaped? What does it mean in terms of what the board can demand, where the board can push and where it can't, and what concessions it can expect to get? The board needs to understand that, and it needs to understand that not a meeting or two before the process is wrapped up. It needs to understand that before the process gets underway.
When I was on the Board of Appeals, yeah, we had professional traffic studies and other studies and engineers. We had all that. We had that knowledge, institute knowledge, when we were doing that. But it's encouraging to hear that you would be there from the beginning. I think it's important for this town going forward that our attorneys be present to controversial or supposed controversial. It's controversial because of the location that the proposer's at. That's the location and the safety of our children in the neighborhood. And that's important to me and others in town, practically everyone. There's a big community group against it. But that's important to me, being a former member of the Board of Appeals and looking at how the current board is constituted. They've never had a 40B. So it's important that the town be proactive than reactive when it comes to a future large development like that.
So you might also note in our proposal, a couple times a year, we'll give training sessions
I saw that.
to the land use boards. We do open meeting law trainings, public record law trainings, ethics trainings. We do comprehensive permit trainings if you want. So, you know, an informed client is a good client. And so that's what we try to make sure everybody's up on things. You let people have questions so you can plan the process out. So we try to work with our clients in that regard.
Mr. Chairman, thank you. I got one more question. We have a unique opportunity here as the board. It's a little over a year for me on the board to possibly save the town money with the new law firm. And from what I read, you're proposing to come to town hall twice a month and then 2 meetings. Is that outside of the twice a month? So
yeah.
say the selectmen have a meeting that they require the town council, and then the Board of Appeals or the planning board have a meeting.
Right.
And then what if there's a third meeting, then it's billed differently, or?
Right, so first of all, I don't know that we've ever actually charged a client if they go over the quota, so
Okay.
to speak.
I'm just going by what.
So,
was
no,
written.
no, because you have to set a base, right?
Exactly.
So, so that's our base. So our proposal is that
think that's a
1 or
great
2
idea, by the
office
way.
hours a month, and then we propose 2 meetings. And then if you need more, then we talk about it. So I presume, but I don't know this for a fact, that your land use boards have adopted Chapter 44, Section 53G, which allows them to charge the applicants for the fees related to professionals that assist the boards. So if we go over those 2, and we're doing that, not on a comprehensive permit, because you can't do it, but other big zoning matters, they pay for those fees beyond the 53. So we would charge $190 a month. You wouldn't pay for it, the applicants would pay for that. But if the board has something controversial going on, they need us here for 3 meetings, we're going to be here for 3 meetings, and you're not usually going to see it. If all of a sudden, every month you want us here for 6 meetings, we're going to sit down and say, okay, look, we can do this, but you're going to need to pay us hourly for the rest. But, on average, it's usually what happens, 1 or 2 meetings a month, certainly the office hours, and then everything else.
And we've never done that. I mean, I think that's.
No,
the important thing,
never.
right? It's never come about. Again, we need to sort of
Why upset a
establish.
client, right? Over
Right, and-
$100 and
No, right,
$190 on. Yeah.
doesn't make any sense.
I have one final question. I apologize. I just thought of it. Our last town meeting, we tried doing a bylaw change for our signs. Is that something that you guys could help us? Any bylaw changes that the planning board or the Board of Appeals or is that something that you could help us, to help the town draft?
Yeah, so both Adam and I have recodified entire zoning bylaws. We recodified sections of bylaws, inclusionary zoning, sign bylaws. I'll tell you a funny story. So when you're doing a recodification, we tell people, you do recodification. If you want your recodification to pass, don't touch the signs and don't touch the adult entertainment, okay? And then you go in and you tell people, and then deal with them separately, right? Because signs and adult entertainment they're triggers for people, right? They have a lot to say about those things. So if you want to do a recodification, recodify everything else, and then do the signs and the adult entertainment separately. So it's funny that you mentioned that,
No,
because
it
signs, a lot of
actually
people have,
happened
a lot
at
of people
our
have,
town meeting. We
yeah,
ended up withdrawing it, thank God.
right.
But I'm not sure how involved the town manager had our planning director involved with the town council
Yeah.
to write that, because our town council was at the meeting.
Yeah.
But we ended up withdrawing it. I just think it's important because it seems like every year that I've been involved in town, we're doing what we call cleanup or fixing a bylaw that was miswritten or something like
Yeah,
that. So I think it's important that we get town council involved with that from the, like I said earlier, the beginning.
Which is town meeting season is a busy time for everybody, and when we're doing office hours, that's actually a really good thing that we do. It's like we can sit with people, it's one thing to all of a sudden get a warrant thrown at you and somebody say, oh, I gotta get it in front of the Board of Selectmen tomorrow night. And it's the first time you've seen any of, and so you don't have a lot of time to talk to the town manager or the planner, why are you doing it this way? And, I might have redrawn it, I might have redrafted it a different way had you called me earlier. So if we're regularly having communications with people, we're in town hall, usually we get to be a part of that drafting, understanding why a bylaw is the way, and we might say, ooh, you're not gonna get it that way, you might wanna go this way. So, yeah, we are part of all of that.
Thank you.
It doesn't mean it will always pass, I might add that.
No, I understand
right?
that.
Let me just say.
Thank you, Mr. Chairman.
To dovetail on some of Mr. Loud's questions and attorney's meeting cost, I believe you touched upon it. I think I just want to hear you say it. Have you ever felt like it would be inappropriate or advised against one of your attorneys being present at any board or committee meeting when there was a particularly controversial issue being discussed?
The answer is no. We've never advised against it unless the Board of Selectmen have requested us not to be there.
Okay.
And I can confirm the same thing based on the communities in which I'm lead or co-lead. Same answer.
Okay.
I'm just curious, and I'll be quick. A couple of quick questions relative to compensation. Can you tell me what community that you would serve would be the least amount that they had to pay you, and what was, we have a population of, what, about 25,000 in there, in that area, a little less. All right, I'm going to even go a little higher. What would be the most compensation that you received from either a town or a city, given the given that
Well, so they're different
population?
if they're hourly
Yeah.
and, so, I have, let me just say, and it depends on what's going on in the town. So if I have an hourly client, for example,
Okay.
and I can tell you this, and there is a lot of controversy happening internally. In this instance, I had police issues and I had Board of Selectmen issues. There were a series of 6 months one year that my monthly bill was not less than $20,000 a month. Okay, that was average. And then all of a sudden, everything went away. And it was about $10,000 to $12,000 a month for this particular community, a little bit smaller than Wilmington. And that didn't include labor. That was not, we weren't, at the time, we didn't have labor practice. We have really, really small communities that don't call us for anything. And if it's $1,000 a month bill, that's lucky.
That's an important point, because
Right.
you see the number, and one of you touched upon it earlier, about do you feel you can provide coverage for Wilmington based upon the number of
Right.
communities you have and the number of attorneys you have. Well, it's not 16 communities that are the size of Wilmington. We've got
Right.
communities like, and it's public knowledge, Berkeley, communities like Deerfield. These are smaller communities. Our average billing is a small fraction of what it would be in a
Right.
community like yours, because the population is a small fraction, and also based upon the location of some of those communities, they're not dealing with the same sorts of issues that you might be. So in those communities, we do very little work. Town meeting time tends to be the busy time of year.
Right.
But otherwise, we can go entire months where we're billing them hourly and their bill is under $500.
Yeah, maybe.
And real quick, relative to 40B, if somebody was to appeal a decision of the 40B, under your fee structure, is that part of the flat fee, or is that the hourly?
Yeah, so that's an interesting thing. Under the all-in flat fee, which excludes the appellate tax board and labor, right? So the all-in flat fee, that includes litigation. So that's everything. And one of the really, I think that, I don't know if Wilmington does this, but there's a number of communities, and I certainly know that I did it as mayor of Newburyport, is that it's April, it's May, and my legal budget is nothing. Right? And so I have an important matter that I might want to appeal. And so I have to look at the legal budget and decide whether or not I have the money to do the appeal. Do I have the money to actually do what I think is the right thing to do for the community? And with the all-in flat fee, you can decide. You know what it is. It's covered. You don't have to worry about it. You know what your monthly bill is going to be. You can budget that all year long. The one that is flat fee, partial flat fee in litigation outside, I have a community who, when we were first hired, they said, you know what, we can control our litigation. I'm not worried about it. We're only going to do the partial flat fee, and we will pay separately for our litigation. And they've done that. You know, they've had a couple of small cases, but since they know what their general bill is going to be, they go ahead and fight the litigation when they want to fight the litigation. They're not held back on it. So, you know, it really depends on management style, Board of Selectmen desires. I have towns that just want to be hourly. They just want to be hourly. Okay, fine with us.
Thank you, Mr. Chairman.
Yes.
I just wanted to raise a question about, on the personnel side, your experience in dealing with cases before the JLMC. If you could perhaps offer some commentary on the challenges of dealing with JLMC, and also how you've advised clients that may be in the process of going there.
Yep, I'm going to let Kate address that question.
Yeah, so in Brockton, we were really lucky in that my entire tenure there, I was there 8 years, we did not go to the JLMC, and we have very strong public safety unions, but we recognize that it's not a great plan to end up at the JLMC, although we almost made it there several times because things are what they are. Sometimes you can't get to where both parties can come to an agreement. But luckily, we were able to pull a rabbit out of the hat and reach agreement. So although we've prepared and planned to go to the JLMC, I actually have not appeared before them.
So in terms of did you have to prepare? Were you anticipating going? Was there a process that you were advising the?
So we were nearly at impasse on several occasions, and there were, let's say, reasons that that couldn't push us that little bit to get past that impasse that we couldn't overcome, and somehow we managed to work around that, and without financial implication to the city, we were able to pull an agreement together. So there were a couple mechanisms that we used. We did 2 3-year agreements, which pulled everything together in a way that worked for both parties. And I think that's always a better approach than trying to succeed at the JLMC for obvious reasons, because your success rate on the municipal side, on the management side, is not great at the JLMC.
Thank you.
Just one last thing for me on litigation issues. It mentions here that you'll have 2 attorneys all the time on any of those types of issues. Would that be the lead attorney or the backup plus an attorney, or would you be giving those off to 2 attorneys that you have in the
So we do it
system?
one of 2 ways. We always have a partner on those cases. Generally, it would be your lead. Now, Lisa will be the first to admit she doesn't frequently litigate, but a good portion of my practice is devoted to litigation. So what I might recommend in this case, if Lisa were to be your lead for your everyday municipal counsel, is if we were to enter an appearance in on a case, or when we enter appearances in on a case, Lisa's name would go on the caption, so would mine, but we'd probably also add an associate in as well. So we had at least 2 people who frequently litigate, a partner as well as an associate, but also your lead counsel named as well. All the notices come to the same firm anyway. It's just a question of who has an appearance in on the case and who's familiar enough with it that they could appear if they needed to on a moment's notice if there's an unexpected status conference or case management conference or a hearing that comes about quickly on an emergency motion.
And one last thing before we conclude with maybe some summary comments, if you'd like. You mentioned you'd be here two times a month,
Right.
but we may not need you 2 times a month.
Right.
So you would make those arrangements with the town manager, that way, kind of stockpiling those 2 days. Is that how that would work if we need you in
For
the
you,
future?
Mr. Chair, yes.
Yeah, okay.
So you'd be surprised. You might need them. Although, you know, July, August sometimes gets a little slower for folks. So we organize, however, it works with the town manager on how they want us. You know, so I have towns that I'm rigidly scheduled, and that's where I show up, you know, every other Tuesday or twice a month or once a month on that particular day. And then I have a couple of towns who just call me and say, can you come in for a day or a morning? So I would make those arrangements with the town manager, however frequently or infrequently as it may be.
Thank you. I think everybody's all set with questions, or
I'm good,
do you
thank you.
have any summary closing
Well,
remarks?
we want to thank you for the opportunity to come back. I think Wilmington is a really interesting community. You have a lot of different things happening, and they all are kind of in our bailiwick, if you will. And so I think what you'll find with us is that we do provide a different kind of service than you might be used to or that other firms provide. And it's just because that's what we want to do. And so I think if you were to call some of our references, they would verify that. You'll get a full-service firm with us. You'll get attention with us. And I think you'll get a partner in your work for your constituents, and we would love to have that opportunity.
And I'd like to add briefly, if I could, if you have questions following tonight's meeting, especially questions concerning the fee proposals. I know those are somewhat unique. We've developed them to be specific to our firm. If you've got questions about those proposals, what's included, what's excluded, what the flexibility is on the numbers, please reach out to us, ask us those questions, we can give you answers. Our goal with the fee structure is to be entirely transparent. One of you asked about, do we get an itemized bill? You absolutely do. You can add up the total hours, you can divide it into the monthly fee, and you can determine what our effective billable rate is. We do that ourselves for our own record keeping. You can do the same thing. You'll see, you know, our partner Jay often says in these interviews, you know, some months the bear eats us and other months we eat the bear, and that's just how it works out. Our effective billable rate has been $60, $70, $80 an hour in some communities at town meeting time. It's just a reality of the fact that we've got to be in those communities a lot at that time of year. And it's better in July and August when things are quiet in many communities. So we're transparent. We're happy to share with you the information that we use to put these fee proposals together and to answer any questions you might have.
Thank you. Thank you. I think we're all set. Thank you very much.
Thank you.
Appreciate it.
Good night, thank you.
Nice to meet you. Thank you for coming.
Nice to meet you.
Have a great night.
Nice to meet you. Thank you for coming in.
Thank you.
Thanks for your time tonight.
Nice to meet you. Thanks for coming in.
So I think at this time, for the purposes of our home viewers, we're going to come back about 7:30 with the new law firm, or unless they get here early, and then we'll start it up early. So we'll hold off a recess at this point in time. Thank you. We're going to reconvene. It's our 7:30 appointment with KP Law. Welcome. Thank you for being here this evening. I'm not going to go through the beginning of how we, at the beginning I gave a little synopsis of how we got to this point in time, so I'm going to, but I will introduce the members of the board to you. It's Greg Bendel,
Good evening, gentlemen.
Mike McCoy,
Hello, how are you?
Ed Loud,
Good evening.
and Jonathan Eaton. I'm Kevin Kyra, we just met, and Jeff Hull, our town manager. And want to start off with some opening remarks and introduce yourselves to us, that'd be great.
Yes. Thank you, Mr. Chairman. We are from KP Law. My name is Mark Rich. With me is Jonathan Silverstein and Joseph Fair. I'll take the initial stab at introductions. As you are aware from our submission, KP Law has been in the practice of municipal law, formerly Copeland and Page, for approximately 45 years now. We have 43 attorneys at the firm, all experienced in all facets of municipal law. We represent approximately 125 municipalities throughout the Commonwealth as city solicitor and town council. We also serve most of those clients as labor and employment counsel. We serve a number of communities as special counsel. So we are the preeminent law firm with municipal law in the Commonwealth, given that our practice is about 98% municipal law. We have a small additional real estate practice that has grown over the years, but we concentrate obviously in municipal law. We also represent regional transit authorities, housing authorities, municipal light plants. We also provide bond counsel services. We pretty much cover all of the areas of municipal law that the town of Wilmington would face, addressing everything from land use, labor and employment, contracting, procurement, real estate transactions, municipal finance issues, obviously town meeting, open meeting law, conflict of interest, public records, all those issues. We offer training and guidance. We offer, again, a comprehensive municipal law program. The way we set up our process for representing municipalities is we have a primary counsel system, wherein the town would have a specific primary counsel contact. In the case of Wilmington, we propose myself as a primary contact. I've been practicing municipal law now for close to 30 years. It's been my practice for my entire professional life. I started off as the assistant city solicitor for the city of Everett. I've been with KP Law now for approximately 20 years. So the way we structure things is to have a primary contact person, so the town always has a single person to go to. Doesn't have to think about who your counsel is. You have your general counsel. Behind me would be my backup, which would be Jonathan Silverstein, and then for labor and employment, an additional backup, it would be Joseph Fair. So in situations where I could not be reached, Jonathan would be available to you. Then behind us would be the 40-odd other attorneys with various specialties at the firm. So you would have the benefit of all 43 attorneys at any different time with respect to specific issues, if it be a land use issue, a real estate transaction, litigation enforcement, drafting of bylaws, things like that. We always have someone available with specific expertise. So that's our general setup. For additional information, I live just up the block in North Andover, very close by and convenient to the town. So very easy to be accessible to the town, not only through electronic means, obviously we all carry our cell phones, but being able to arrive at Town Hall at essentially a moment's notice would be fairly straightforward, given the close contact. I'm also aware that you have a Saturday town meeting. I do a number of Saturday town meetings, none of which conflict with yours. And I always find the Saturday town meetings a great opportunity to meet with the town. So that is something that is consistent with what we look to in our towns to provide that service. So with that being said, I would, unless anybody of the board has any questions, I'd like to give the opportunity for these two gentlemen to introduce themselves.
Great. Thank you, Mark. Well, I'm Jonathan Silverstein. My specialties are in litigation and land use. I've been practicing at KP Law for 22 years plus. I only practice municipal law, land use, and litigation, and I view it, and I think Joe and Mark feel the same, and everyone at our firm, we view municipal law as a calling. You don't go into municipal law to get rich, that's for sure. I would much rather be representing the town on a big land use issue than a developer, even if it's a cooperative relationship. My approach is to cooperate, but get the best deal for the town. And if it's not a cooperative relationship, if it's a development that the town has objections to, then my goal is to find every single argument possible to ethically oppose that development. And I've been, as I said, doing that for over 22 years. I also live close by the other way. I'm in Lexington, so I could also be in Town Hall pretty quickly if ever the need arose. I've had chairs of ZBAs call me up and say, we're having this hearing, it's going south quickly, can you get here? And I throw on a suit and hop in the car, and that is certainly something that I'd be prepared to do. I should note, I have just a collegial working relationship with the chair of your ZBA. I've known him for a couple of years, and I think we could work very well together. And I am familiar with the types of issues that the town is facing. I've read some of the press about some of the hot button land use issues that the town is facing. I'm familiar with those issues. I've worked on them for other towns, and I'd be prepared to step right in and assist the town with them. So I'll turn it over to Joe, and of course be happy to answer any questions you might have later.
Thank you. Good evening to everyone, and thank you for this opportunity. My name is Joe Fair. I've been practicing labor and employment for approximately 21 years now. I've been with the firm for about 14. You know, the types of issues that we deal with in our group, labor and employment, again, it runs the entire gamut of what cities and towns encounter. So anything from collective bargaining negotiations, civil service commission issues, unemployment assistance, Department of Labor Relations, Joint Labor Management Committee, MCAD. It runs the entire gamut. At times when it rises to the level of superior or federal court as well. So, you know, we're a full-service labor and employment group, providing essentially everything that a city or town needs in that field. The biggest, I'd say, component of what we do in the labor and employment group, though, is on a day-to-day basis, is really trying to keep clients out of those venues to the extent possible. You know, clients coming to us in advance and working them through issues, counseling them on the best way to, you know, navigate around those landmines that can sometimes appear, whether you like them or not, you know, is one of the things that, you know, we take a lot of pride in doing to make sure that you, to the extent possible, stay out of those arenas. It's not always avoidable, and when it's not, you know, we're obviously very well prepared and equipped to go in and handle the town whether it be a defense or if the town's on the offensive in a particular situation, handle that as well. So, you know, as I said, I've been with the firm for about 14 years. To expound a little bit in terms of how the team setup is, you know, I would be the designated labor and employment counsel, Jonathan serving as the backup in land use, and Mark, we all have our own specialties. You know, that whole function that we have as a team is what we try to give you, as Mark said, you know, the 43 attorneys behind you, but you're dealing with a smaller team, so it's a small firm feel, but with the resources and the economies of scale that come with having a firm that has the breadth of experience and the scope of coverage that we have in terms of all of the different practice areas. I myself, as a labor and employment attorney, actually spent the first 6 years of my career on the union side of things, which, quite frankly, I think has given me a very unique perspective that some management side attorneys never experience because they spent their entire career on the management side. And, you know, so it really gave me sort of the ability and the insight to look at the labor and employment issues from the employee side, and has given me that perspective so that I have, you know, really I'm in a better position, I think, than some to really kind of identify the best way to navigate, because I have an inside look in terms of how the unions operate, how they function, how they think. So I have found that to be very valuable through my career with KP and Law. So that's just a general overview in terms of who I am and what I do. I'm also an avid Boston sports fan, so I'm also happy to talk about anything along those lines with anyone at any time.
I know that you told our screening committee about some contaminated wells in Sturbridge and work that you have done with W.R. Grace in Woburn. I wonder if you could expound upon that a little bit.
Sure, I'm happy to. Jonathan and I worked on the Sturbridge matter that involved, and actually it's interesting, we had several cases at that time involving contaminated wells. We worked in Sturbridge as well as in Kingston in situations. We also worked in Walpole. And Charlton. Yeah, so we've had several situations where we have had to address Chapter 21E issues. We've actually addressed 21E issues on both sides, both in defending municipalities with respect to releases. I'm involved in one right now, and then in addressing claims being brought by the municipality under Chapter 21E, Section 4A for response action costs. In the Sturbridge case, we were dealing with several major oil manufacturing companies whose gasoline stations had released gasoline petroleum products into the town's wells, causing MTBE and other contamination within the wells. And we followed through on the Chapter 21E, Section 4A demand process, and brought the case through to successful negotiation of a multi-million-dollar settlement for the municipality. With respect to the Woburn case, obviously, you've all seen the movie A Civil Action. This was kind of the second phase of that case, the remediation of the contamination that occurred that is in the area that's now the Anderson-Woburn Transportation Center. They didn't get to make the sequel to the movie. I was very eager to know who was going to play me in that movie. I think the sequel would have been a lot less interesting, because what we were addressing at that point was really making sure that we had appropriate remedial actions and appropriate land reuse. We worked very closely with a real estate trust that was involved in the reuse and redevelopment of the properties, including the Target plaza that's in place there right now. Essentially, the entire Anderson-Woburn train station and the plaza across the street is a giant cap. And then if you've ever taken the train from Anderson-Woburn, you'll see as you go along the lagoons along the train station, along the railroad tracks, and those are the retention ponds and basins that address the contaminations. We were involved in working with the attorneys for Grace and the attorneys for the land trust that was involved in the redevelopment to make sure that the remediation was properly addressed, the holding tanks were properly constructed, the mechanisms whereby the water came in and did not come back out to address flooding issues. We were actually involved in some fairly technical aspects of that to make sure that the city of Woburn had protection in case of additional releases, and advance the interest in proper land reuse.
I noticed that in the bios you do have extensive background in environmental issues. Would you be the lead when it comes to the issue that we have with Olin right now?
Yes,
You would
yes,
be the
yes.
the point person on that?
Yeah, and what we do, the way I deal with a lot of the technical and the various matters involving the regulatory process, the MCP, the Massachusetts Contingency Plan, worked on Superfund, and which is the federal regulation, and then Chapter 21E, which is the state environmental law. Jonathan handles the litigation end of it, so we've worked very close together on both of those issues. If the matter proceeds through to a litigation front, Jonathan is the one who has handled the litigation. So we work as a team on the litigation and claims process, but I would be the lead person with respect to any environmental issues.
And just to hop in really quickly on that Sturbridge case, that's what happened. Mark was seeing the case through, and we were, the defendants there were ExxonMobil, Shell, and Arco. I mean, we were talking about some pretty major companies that were playing serious hardball and figured that this small town in central Massachusetts wasn't going to stand up to them. And we showed them otherwise. We took them to federal court. It didn't settle during the 21E demand process. We went to federal court. We ended up mediating the case and getting a really good result for the town. And that's exactly how it worked. Mark, was the technical guy working on all the hardcore environmental issues, and he worked with me on the litigation.
And you know that New England Transrail is another issue that we have in town that is proposing to come in on the Olin site as well.
We're well aware of the New England Transrail process. We worked in Woburn. We also represented the city with respect to New England Transrail and fought their operations there. So we've dealt with that. We've dealt with Surface Transportation Board issues involving the transport of materials by New England Transrail. We've had a lot of experience with that entity. We're well aware of your issue as well.
Educate me a little bit. How is Transrail involved in Woburn?
The intent was to essentially use a rail system to bring the solid waste through.
Okay, so they're just moving north.
Yeah.
Okay.
And
Got it.
yeah, and we were successful actually in stopping it. It did not progress. It was an interesting issue. I mean, when you get into the Surface Transportation Board issues and arguments about preemption, it becomes very interesting. And in the Woburn situation, they were not successful.
Thank you.
Yes,
Yeah, just a couple of quick questions. I'm just ask one or two and I can come back. You said you have 43 attorneys. How many communities did you say you serve? 100 and?
Approximately 125.
125? So, you're looking at just like one attorney close every 3 towns. And I did ask that the other law firm that was here just a moment ago. How do you feel? Do you think you're pushing yourself too thin on that? Or
I get that.
Do you think, I'm sure you get that a lot, but,
I do.
But we need to hear that because I've been around a little bit, and that's a concern, I would think. But I'd love to hear you answer that, and you've done it before.
Well, I think one of the main things, again, in developing these relationships is figuring out who has the best fit and who can address what issues. Mm-hmm. And in my practice in particular, and as we talked about with respect to litigation, I don't litigate. I don't go into court. One of the reasons I don't do that is I want to be available for my clients. I oversee litigation, and there are occasionally cases that I do enjoy to get in and argue a motion, but primarily I want to be available for my clients. So litigation does take up a lot of time. And we have the resources to address that. But in terms of my practice, my chief goal and my chief role is to be available to my clients on a 24/7 basis. I think if you speak to any of the towns that I represent, I pride myself on rapid response, being available at all times. Especially, every selectman in my towns and every counselor in my cities has my cell phone number. It's available at all times. I'm constantly I'm texting and emailing and talking to my clients on a very regular basis. I rarely have not been available to a client, and usually when I'm not available to a client, it's when I'm on vacation, and then we have the backup situation. But in terms of being able to cover it, we look very carefully at that issue. And I do not feel like I'm stretched thin. I feel like actually I I really enjoy the communication with my clients, and it's worked out well. It's served us very well. Again, building that relationship and being available. So it's not a clear numbers game in terms of looking at how many clients and how many attorneys. It's the effort that's put in by the individual attorneys. It's the knowledge that we have so we can resolve matters on a rapid basis. It's not having a steep learning curve. The experience that I have so that I can address issues quickly and effectively, so that when you call me, I'm not trying to figure something out and going back and relearning. I have that knowledge, we have that knowledge, and we can address these issues.
I was going to also, just if I can, to Mr. McCoy, Selectman McCoy's question, keep in mind that some of, when we're looking at 125, communities across the Commonwealth, they range in size, so they also range in the demand on legal services. So, we have towns, you could have a population of 25,000, you can have a population of 500. So we're counsel to them as well, but the demand on legal service is much lower. So that number might be a little bit deceiving. I can say, though, that, when we submit a proposal for, a town such as Wilmington, when we're coming into a place like this, we understand the extent of legal services and the demand on legal services. So when we're constructing, I think this Mark was alluding to, we're constructing a team behind it. It's a team that has essentially the bandwidth that can step in and meet the expected demand that, or our anticipated demand for what you would have. So we take that into account, when submitting a proposal for a town such as this.
And I noticed on the website, a lot of your clients out in the western part of the state. I'd just like to know what you have here, because you say you live right in the next town and you live in Lexington. You serve any of the communities in this general area?
I'm counsel to Bill Ricca, as an example. I'm also on counsel to Newburyport and Amesbury, the town of Air. So I have a number of clients in this area. So obviously North Shore is preferable for me and my wife, who likes it when I'm able to get home a little earlier. But as an example, last night I was finishing up a town meeting in Freetown, and I represent the town of Heath, which is way out in the western part. But that gets back to Joe's point that Heath has a population of, I think, under 1,000 people. There are more sheep than people in Heath. So while we have towns like that on our roster, their legal budget is maybe $7,000. And they're very careful in spending those dollars. So you can imagine that their demand on our time is much less. But in terms of our concentrations, we do look at the geography of it, and the area, obviously where you live, it makes it beneficial, so you could be more available to your clients.
And sorry, Joe, for me, just to your question, I am both the primary contact and the land use contact in Sudbury. I'm the land use contact in Westford. And we all, on an as-needed basis, will step in for other, cities and towns that may need our representation at any given time. But we're town council in Weston. We're town council in a lot of communities in the area. And just stepping back to your question, I was going to make the point about, I'm the primary contact for the town of Sandusfield and the town of Middlefield. When they need something, they need it just like you do. It's just far less frequent. And they're happy to have professional town council services, but it's not as demanding. In terms of responsiveness, I'd encourage you, talk to anyone talk to the town manager in Sudbury, Melissa Rodriguez. Talk to the planning director in Westford, Jeff Morissette. We really do pride ourselves on responsiveness, and as Joe said, when we're putting together a team, we're looking at a lot of things. We're looking at, from our research, what sorts of issues is the town likely to be facing, and are we putting together a team with the type of substantive knowledge that's going to deal with most of those issues? Who has, as Mark said, the bandwidth, the space on their plate to be able to service. A town like Wilmington is a major client with big issues, and that's why you have 3 of the most senior lawyers at the firm. This would not be the team proposing for a smaller, less sophisticated community. So we're looking at all of those issues when we're putting together the ideal team to respond to an RFP, such as the one that you put out.
And not to beat this question into the ground, but one of the advantage because of the size, with the, as I mentioned earlier, the economies of scale, our ability to respond to issues, we think is far, far more efficient than a smaller firm would be, because we have so many folks that specialize in the different areas, that if a question comes in, and given the breadth of communities that we represent, there's very little that cities and towns face that we haven't dealt with before. So there's not a learning of a new issue. It's a matter of sending out an email. If it's for an issue to any one of us, we're sure there's someone in the firm that has dealt with that issue before. So our turnaround time in terms of addressing the issue, we think is far more efficient and superior because of the size.
All right, thank you, gentlemen. I'm good for now. Thank you.
Mr. Chair,
Mr.
thank you.
Bennell, yep.
Gentlemen, very impressive, obviously, presentation and resume.
Thank you.
And one thing I think that's even more impressive than the number of clients you have is, I'm looking at the number of clients and for how long you've had them. I think I've lost track of how many cities or towns you've represented for 25-plus years. I find that to be very impressive. So obviously, you're doing something right.
Thank you.
My question perhaps is best suited for Mr. Silverstein. I could foresee in the near future here in Wilmington the possibility of some issues surrounding land use. So perhaps you could expand upon some of your experience. Is it just you? Is that correct, that you would be the go-to on the land use? Is there others in your firm? I would imagine there are.
We have a very deep bench in land use. As you can imagine, land use is sort of the bread and butter of municipal law. And so we have a deep bench. I would be your primary contact when it comes to land use issues. But I am backed up, if I'm on trial for 2 weeks, which does happen from time to time, it doesn't happen all the time, but a pressing issue comes up, I have, half a dozen partners and then more associates who are ready to jump in and deal with your issues. In terms of my specific experience in land use, I have tried, I couldn't tell you how many cases in the land court on zoning, subdivision, control, title issues. I've had SJC victories on title issues for municipalities. I can't tell you the number of municipal hearings that I've represented, the boards holding those hearings. I think that is really critical in my view, is when a municipal board is holding a hearing on an issue that has good likelihood of leading to litigation, that's the time when you want your counsel present to be guiding the board through that process. A lot of times it's appropriate, it's spelled out in the law, and it's appropriate to have the applicant fund town council being present at that hearing. But even if that's not an option, a lot of times it can be very critical and cost effective to have counsel present at that early stage to head off problems down the road, or at least guide it towards a more defensible position. So, literally hundreds of hearings I've attended of municipal boards. I learned from one of the best land use attorneys I know, who is now the Chief Justice of the Land Court, Judith Cutler. She was my mentor at the firm until she went on the bench maybe 8 years ago or so. I've appeared at all levels of state and federal court on land use issues, from adult entertainment to someone wanting to put a dormer on their house to, multi-hundred unit 40B projects. I have experience at the Housing Appeals Committee with respect to 40B projects. So, as I sometimes say, I can go on for hours about land use. My wife doesn't love it. But offline, I'm happy to tell you more at any point, but I don't want to suck all the air out of the room.
Appreciate it. Thank you, Mr. Chairman.
What kind of approaches are you seeing in other communities? I guess, what other approaches are you utilizing in other communities for affordable housing?
That's a great question. So, being proactive when it comes to affordable housing is one of the best ways that a municipality can help to protect itself from what's colloquially called an unfriendly 40B. Obviously, the flip side of that is that there are what are called friendly 40Bs, or also known as LIP, or local initiative projects, where the town works with the developer and tries to help to shape a development in a way that is attractive to the town, helps to develop affordable housing, and helps to build up the town's subsidized housing inventory to protect it from hostile 40B. There's also, of course, the ability to have an affordable housing trust. To some towns adopt the Community Preservation Act to help to leverage some state money to go towards affordable housing initiatives. I've worked with the town of Boxborough. I had a big case for the town of Boxborough a number of years ago where they went after excess profits of a 40B developer. And we recovered in excess of $1 million for the town. And it put those funds towards affordable housing buy-down program, so that when a market rate unit that would be an appropriate unit for an affordable housing unit was going on the market, they wouldn't buy the unit because that would take up a whole bunch of their money that they had available. Instead, they would buy an affordable housing restriction, which obviously cost a lot less money, kept the unit in private hands, but added it to the subsidized housing inventory, and we work closely with the town on that initiative. There are all sorts of initiatives, and it's really a matter of how creative the town wants to get and how serious it is about wanting to tackle the problem, which we know is a real problem. I have serious disagreements with the way the state has chosen to shift the burden onto municipalities by calling projects subsidized where they're not really subsidized. They're just, the subsidy is a waiver from local requirements. That's the state's subsidy. But we could talk about that another day. But there are a lot of really good programs that are out there. And incidentally, I mentioned Westford. Until last year, the planning director, Chris Clutchman, was the planning director in Westford. She left to head up a new housing initiative. It's a multi-departmental housing initiative. It's housed in DHCD, but it's not under the auspices of DHCD. It's direct report to the administration. And they're coming up with a lot of really innovative approaches, and she's a great person to work with, and certainly someone I would encourage the town to work with in the future.
Thank you.
I have a couple questions. You mentioned Woburn earlier. I was actually growing up in Woburn with the current town manager of Bill Ricca. How long have you worked in Bill Ricca?
We've worked in Bill Ricca now for, I think it's, well, we previously worked for Bill Ricca, a number of years ago. In fact, I did a lot of environmental work there on the Schaefer landfill. Currently, we've been working in Bill Ricca for, I think it's 4.5 years now. I've been the primary contact there with John Curran, who I assume is former mayor of Woburn. Yep. And John and I encourage you to contact him as a contact. John and I have a very close working relationship. I work very closely with that board of selectmen and John. It's been a great working relationship. Bill Ricca is an interesting community with a lot of challenges, and we've been working very closely with them. We've worked through. They have the high school project successfully ongoing. We work with them on that. We just recently successfully are in the middle of successful litigation on a challenge to the Middlesex road project, the very large roadway heading to Route 3. That was the taking challenge that recently went through the courts. So we've been involved in a lot of interesting issues in Bill Ricca.
You mentioned briefly, and I'd like to have you elaborate a little further, a big topic in town is Olin, and do you have a lot of experience at the federal level, because it's a super fun site? And you mentioned Woburn, but was that at the federal level, or?
Woburn was a Superfund
yeah,
site.
I remember that.
Is a Superfund site.
I know that.
Yeah. So we By the time we became involved in the Woburn site, much of it had been resolved in terms of obviously litigation. That was more the land use and reuse. But we've been involved in the bird landfill or the bird property in Walpole. We've been involved in the Beatty Waste Oil Superfund site. We've been involved in a number of Superfund projects. And so, we do have a great deal of experience with RCRA and the Superfund laws. Met with the EPA and regulators from the EPA and the Attorney General's office and the federal attorneys to address EPA issues and Superfund issues. So we do have a lot of experience. Obviously, we deal quite a bit more with on the local level in 21E because most of the sites you deal with the oil spills. The general contamination issues are local issues that don't reach the level of Superfund. So we spend a lot of time dealing with claims. I've got one that I'm dealing with right now in Ayer with it's as simple as an overfilling of an underground storage tank that resulted in an oil contamination that has gotten into wetlands. But that's purely 21E. That will never wind up as a Superfund. But yours is much bigger than that. And yeah, we do have extensive experience with that. We have a team of folks who do environmental law. And
Thank you for elaborating on that. My experience, I was on the Board of Appeals for many years. I had a lot of experience in town with 40B, and I see that coming down in the future because in 2020, the way we're going right now, we'll be under our 10% limit. And you mentioned some initiatives. One that the town is looking at is an inclusionary bylaw. Is that something that you could help the town develop? Because we're hoping to have it sooner rather than later.
Absolutely. I've worked with a lot of municipalities on inclusionary zoning, from the city of Everett, where I do a great deal of special they obviously have an in-house law department, but I do a great deal of special counsel work for the city, a lot of zoning and land use work for them. They just adopted an inclusionary zoning ordinance to the town of Provincetown, obviously very different complexion. Every town, it's not a one-size-fits-all thing, so you really have to know the community. You have to be able to articulate what the impacts of each, of market rate development is in order to justify what the inclusionary level is going to be. But absolutely, I've worked on many.
That being said, and you mentioned that it's better for you to be proactive and at a meeting that the Board of Appeals is in front of at the beginning instead of at the last couple meetings. Some of the other things at our last town meeting, we tried doing what we called house cleaning, and we do that a lot with our zoning bylaws at town meeting, do what we call house cleaning. As a town council, would you review that warrant and make recommendations?
Oh, absolutely. I mean, that's what we do.
We had one we had to withdraw from. It was signs, and it was a huge debate, and we ended up withdrawing at the town meeting. So that's one that I know that needs to be cleaned up because it's probably 4 or 5 pages on our zoning bylaw.
A lot of signs, especially since the Gilbert decision, the U.S. Supreme Court decision a couple of years ago. Signs, I'm hired by municipalities sometimes to do wholesale rewrites of their bylaws, zoning bylaws, but we review every warrant for our communities. I mean, that's 100%. Like that's sort of that's another part of the bread and butter, I guess, of municipal law. We review the warrant. Yeah. So the warrant would come into Mark. He'd look at all the municipal finance issues, the general municipal issues. He sees zoning, he's going to send it to me. No offense, you wouldn't want Mark looking at your zoning, and you wouldn't want me looking at, some of his procurement issues. But yeah, I mean that's critical. You can't have complicated zoning issues going in front of town meeting without town council review. You can. I just wouldn't recommend it.
So we as a selectmen, select board have a unique opportunity here to hire potentially a new town council for circumstances beyond our control. So I see it as an opportunity to save the town money. How do you guys propose on saving us money? We spent, I think, too much money last year on town council. you might have seen that contract, I'm not sure, but I'm looking forward to seeing us potentially save money.
I think that's a great issue. We're very sensitive to the cost issues. Again, we represent tiny communities and larger communities, and it's always our goal to reduce legal spending. We think that there are a number of efficiencies that will assist with that. And just as an overview of this, obviously we included a financial component in our proposal, but just so you're aware, it's based on an estimate of the size of the community and the issues that you're facing. But it's certainly something that's subject to discussion, and we want to make it clear that, you know, this is a proposal, and we welcome the opportunity to discuss it further and negotiate as necessary. But to answer the question primarily, as Joe said earlier, there really are no issues, municipal issues, that we haven't seen before. We have a raft of documents at our fingertips. You know, one of my specialties is contracting, procurement, and construction. And I have a raft of Chapter 30B goods and services contracts, Chapter 30, Section 39M public works contracts, Chapter 149 public buildings contracts. If you send me a contract, you know, I'm going to know what to do with that contract very quickly. I'm either going to recommend revision or recommend rejection and substitution of a form that will work for you. Things like that, having kind of a stable of documents and information, and the fact that you've got individuals who know the issues, who don't have to reinvent the wheel every time an issue comes up, again, saves you in terms of not only economies of scale, because we've seen it before, but just the knowledge that you're a very sophisticated town. You have sophisticated issues. You expect sophisticated counsel. We rise to that, and we're able to jump in, you know, at the top level and assist you very quickly and very efficiently. We are not going to have someone who's going to say, "Let me get back to you. I'm going to take a couple of hours to research that before I can answer a basic question." We're going to answer your questions. We're going to answer them rapidly, efficiently, effectively, and in a manner that they're defensible responses. They're going to put you in a good position going forward, so that your decisions are well reasoned. As an example, your warrant, and that's a really good point. Town meeting is a huge component of what town council does or should do, reviewing those warrants, making sure that everything on your warrant is in proper form, so that when you come before town meeting, not only do you have a solid warrant, nobody wants to be embarrassed at town meeting where someone points out, hey, there's that mistake and that article can't go forward. We need to make sure that everything that goes on the warrant is properly vetted and is in proper form. We've worked obviously with the Municipal Modernization Act, so we can advise you on changes in the law and make sure that everything is up to date, because we see a lot of warrants where there's the continued use of old articles that have become ineffective and out of date. We're up to date on all those issues. We're up to date on the public records law. We're up to date on the conflict of interest law. So we can effectively and efficiently advise you, and I think that saves you a lot of money.
If I could just jump in for a moment to Selectman Loud. You know, one of the other services that we do provide is we do provide training, free trainings to our clients. So by us educating, you know, board members, for example, on the open meeting law, that saves you from a litigation standpoint, open meeting law complaints and things, because as we see, and typically there's always one or two in every town, there's somebody that's paying very close attention, as they should, but you'll have a raft of open meeting law complaints that can sometimes flurry in because a particular board may be having some difficulty navigating the open meeting law, because it's not always the easiest law to understand.
Bill Ricker has had fun with that.
So us coming in and providing trainings and trying to be proactive is one way. And I think also too, you know, the comment that I think was made by Selectman Mendel earlier, you know, in terms of the list of clients that we've had for as long as we've had, you know, if we are consistently over spending legal budgets, we don't get to represent that many towns for that long a period of time if that's our track record.
So I got one question. You had mentioned the sports fan, so I am too, but is Wilmington a large size market or a small market or a medium market? Just so I can, you know, you're talking about the TV markets in the sports world.
Well,
like Boston's a large market.
Yes.
Is Wilmington a large market, a medium market, or a small market?
See, it all depends if you live in Wilmington.
Yeah.
Because I think, you know,
that's true,
just like in any community, you know, you're a large market. You're more of a medium market, but I mean, the reality is you're close enough to the city. You are really part of the city market, I would say.
Just to make
My
sure I
personal
understand the
opinion.
question. Are you analogizing you as a client?
No, I'm just trying to figure out where we fit in the, I don't see us as a large market, but not a small market either.
As a client, you mean?
Yeah, yeah,
Oh,
as a
as a
client.
client, forgive
As a
me, that- I
client,
didn't
you're
understand.
actually,
Pretty good size.
yeah, and so that, I'm glad you asked that, because that leads me into a point I wanted to make about our proposal. As you know, as you said, yes, we're familiar with what your current contract is. I'll be honest, it raised my eyebrows a little bit, because comparable communities, I would have thought could come in at a lower budget, but there are smaller towns that have a lot of litigation, and they want to bring a lot of litigation, they want to enforce on every zoning case, you know, and so that can drive legal dollars. And so we're not in a position to say, have you been spending quote-unquote too much money? Because we haven't worked with you yet.
That was my opinion.
Y-
Just so you know.
Understood.
Yeah.
But so when we're putting a proposal together and we look year over year what you've been spending, you know, let me say most of our towns do not opt for an all-inclusive retainer type of arrangement, which is what you currently have. We wanted to make sure to give you that option because it is what you currently have. But in doing so, obviously, that creates risk, that if we were to substantially cut that from what you've been spending year over year, and if that was the right number, you know, we have to pay our people, right? So, so we came in essentially right where you currently are in terms of that model. I personally would not necessarily recommend that model, because you may well end up paying for services that you're not using. You might not require that level of expenditure, and in my experience, comparable communities, you know, don't necessarily. It might be a big case in a given year. You know, if Olin goes to trial in a given year, yeah, you might spend a lot of money. But in other years, you might spend substantially less. So just, we're happy to honor that model if that's what the board is used to and more comfortable with. Or you can say, look, we'll go with a straight hourly model, and maybe we can come up with a not to exceed so you don't have concerns about blowing the budget out of the water, right? But that's just, you know, to your point, that might be something for the board to consider. And then once we've worked with you for a year or so, and if you're still interested in having that real sheer predictability of going back to the straight retainer model, well, now we've collectively got the experience working with one another to know, is that figure just too high? Because I'll be honest, it seems high to me, but I haven't worked with the town. I mean, if every single public employee has direct access to town council to ask whatever question they want, and, you know, Mark and Joe and I are getting, you know, 5 hours of phone calls each every day, then yeah, maybe that's the right number. But I tend to doubt that's the case.
Do you track hours for clients that are on flat fee?
Absolutely.
Do you have any municipalities that are on flat fee?
We do. Well, most of our municipalities are hourly rate.
Okay.
But whether they're hourly rate or flat fee, and regardless of the model that we use, we track the hours. And it's interesting, I mean, I was just having this discussion with one of my clients, trying to analyze where their legal dollars were going, and we sat down, we looked at what was going on. And you know, I always when I do budget hearings for towns that do have us before them on budget hearings, I always remind the clients that we are reactive. We're not like the departments where they come in and they request their budget. And we work with you to set that budget, but we are reactive in terms of, as Jonathan said, if you are seeking to litigate every decision, defend every decision, move forward with enforcement action.
Do you invoice municipalities that are on flat fees?
Absolutely.
So we would get
And
an itemized
you'll
bill.
see a detailed invoice.
And that's exactly what assists in these discussions is we can sit down and say, all right, here's where your legal dollars are going. You had this particular real estate issue, and it mushroomed because you had a lot of demands, and the other side had a lot of demands, or this particular enforcement action you wanted to proceed through every avenue, or you wanted to defend this particular decision, or there was a complex real estate transaction there. So by tracking with the invoicing, we can determine where those monies go.
Your proposal had referenced state-of-the-art computer systems several times. What are you referring to?
I think what we're referencing there is between the linking of our computer systems, the research facilities that we have available to us, the archiving of materials, our ability to archive, to maintain document storage, data storage, and in terms of, and none of the three of us sitting here are they're computer experts. Luckily, we have folks who
Do you have case
do that
management
directly.
software?
Excuse me?
Do you have a case management
We do.
software?
Yes.
What is it?
It's, yeah, Janelle works with it. I'll come up with the name. I want to say it's, not Divergence. I'll think of it in a moment. I'll be quite honest, the 20-year-plus attorneys sitting in the room are not the ones working with it most
So you're not
closely.
utilizing your case management software?
We manage it through the associates who actually and partners who handle the specific cases. They usually update us on those issues. We're probably less facile with those things than our younger colleagues.
But I know that the capabilities of it for large-scale e-discovery, and I know what the capabilities are. I just, quite frankly, am not, when someone's going to be reviewing 10,000 pages of documents for
Well, not just
particular
for
work.
e-discovery work, but just day-to-day, like you're using a Clio or using anything.
I'm not personally.
All right, well, I mean, if you weren't, then nobody else, I mean, it's more of a day-to-day type of thing. All right. I have nothing for now, but.
Just want, thank you, Mr. Chair. Just want to ask you a quick question. In your proposal, you're looking for what, $26,000 a month in 2018, and then you're looking for what, $27,000 in 2019? That's what it says in the proposal.
Mm-hmm.
I just want to tell you something. A moment ago, you said you thought we were paying too much, and you always open up room for negotiations. Maybe if you get the job 2 years. I'll be honest with you, it's like you're looking at, and you had information looking at the previous, at our town council. I opened up a restaurant. 31 years, and I'll talk layman's terms. Very successful. I did fantastic financially, and it worked here, and I sold it. And if I'm selling fish, I get a lot of vendors come in, and they say, oh, you're paying too much. I can cut that price a little. And about 4 or 5 months from now, I'm paying 20% more than I did with my guy from Saugus. I just have to say that, because you're saying it's too much, but yet your proposal is more than what we're paying right now. And you project that for the next 2 years. And you say, if we give you the job, that maybe in a couple of years, if maybe this flat fee will work out for us, maybe it won't. But with all due respect, for you to say that, that bothers me, to hear something like that. You're coming in at more money than we're paying, and you just said a second ago, we're paying too much.
Well, let me speak to that
seriously.
if I could. And I tried to address that in my earlier remarks, but let me try
you
again.
did, but go ahead.
We essentially came in at, I think right now you're at 308, and so we came in at 312 as a flat fee. As I said, we're not in a position to know if that's too much, because I haven't worked with the town before. And so for us to come in substantially lower, we could lose our shirts if that is essentially the services you're using. I don't think, from my experience with similar communities, that you need to be spending that much. But I don't know that, and that's why what I said earlier was you may want to think more about an hourly with a not to exceed. For instance, we could say we'll go on straight hourly, and the 312 will be a not to exceed number as opposed to a flat retainer. That way, if you're not using that money or those services, which I suspect you're not, then you're saving money. But I can't come in and say, we'll do it for $250 without having worked with you and knowing that that's the right number. It might be that in a year or two, where we've done it at hourly and only billed time worth $220,000, that we've confirmed what I suspect. But we're not in a position, if what the town really wants is to have a flat retainer that's all-inclusive, we're not really in a position to substantially undercut. Now, as Mark said, we're happy to negotiate. If you say, we want to work with you, but 312 is too much, of course we'll work with you. But we're coming in, not having worked with you, it's hard to expect us to come in at, 100,000 less.
I wasn't expecting you to, like, lowball us to come in at a cheaper price, and I heard Mr. Loud saying he wants to try to save money, and I get that. I'm not expecting that, but just the comments that were made, I just look at that, and I look at it in a big ball here. And let me ask you another question, if I could. I noticed on the website that you folks give talks to the MMA, and your law firm. Is any of members of the law firm actually set those laws at all? Because I know on the MMA you can work to set laws. And are you any one of those attorneys that help set laws, or?
Oh, no, yeah, the MMA lobbies and proposes, and we work with them in terms of providing training and being available, because the MMA will set up events where we're available to give seminars. Usually they'll have a selectmen's breakfast, town administrator, town manager's breakfast, a mayor's luncheon, and they ask us to come in and give talks. We will provide comments on, we provided comments on the new open meeting law and the new public records law. We submitted comments. We meet with legislative aides and representatives and legislators. We meet with the Attorney General's staff to discuss various initiatives. But we don't work for the MMA drafting legislation for them.
No, because I noticed on the pictures, I noticed on the web that you show a lot of pictures, giving a lot of talks to MMA. But what I'm wondering is, are there attorneys that represent municipal government that actually help set the laws? Are there some of those attorneys that do that?
Well, again,
You mean drafting the legislation?
Not
or-
drafting legislation, but at the MMA, I mean, there's some attorneys that actually set the laws.
When you say
For
set
municipal-
laws, I think, could you, I'm having a hard time following what you're asking.
No, what I'm saying is, no, I know that. What I'm saying is, aren't there attorneys that, in the municipality, that actually at the MMA help set laws up down the road?
Advocate, are you talking about maybe advocating for particular laws?
Well, I would say, advocating for yeah, I would say it that way. In other words, they're there to help put it along, to create laws.
We draft special legislation for our municipalities for their specific needs and interests. And sometimes a municipality has a particular project or particular issue, removal from civil service for certain positions, or a change in management structure, creating positions for towns. In terms of state law, again,
I know the legislature, that's the state law, I get that, but isn't there some members in the municipal law that help, well, like the manager said, help put that along to help move that?
Certainly, we advocate,
Yeah.
we do lobbying. We have a guy, Matt Fair, who's on the executive board of both the MMLA, the Mass Municipal Lawyers Association, and on the MMA. And for instance, he was closely involved in drafting the P3, public-private partnership legislation that's incorporated into the governor's, the act that was proposed to help deal with climate change. It puts a lot of money on the table for public-private partnerships and water projects. He's deeply involved in water infrastructure projects. I'll be honest, we're not lobbyists, so that's not what our role is. We advocate for legislation when our municipalities want us to.
I
I've
understand the legislature,
testified
they
before
write
the
the laws, I know
legislature.
that, but obviously, they're not all lawyers up there. So obviously, they're gonna be looking, when you're there advocating, at the MMA, and then somebody looks upon that and say, well, that's what we need to do. All right. All right.
And the example I was using, again, the recent changes to the public records law and the open meeting law, that we reviewed what the proposals were, and then we made our suggestions and recommendations that we thought were beneficial to municipalities. but we do it specifically to benefit the municipality. It's always on the municipal
Yeah,
side.
I just left a conference, for the retiree administrators down there. They had their conference, and there were attorneys from various law firms that spoke and, gave their input and advocated, and I would assume that that's done at the MMA as well, so
That was the whole
doesn't seem
point.
to
No,
be an
thank you,
issue
Mr.
there.
Chairman.
And a
I'm
lot
good.
of
Thank you.
times, we work closely with just about every state agency that a municipality will interact with. And so if they're going to be issuing regulations or recommending legislative changes, they'll often seek our comments, knowing the number of municipalities we
When you
represent.
represent about a third of the state. anyway,
Exactly.
close
Well,
to it.
as an example, I sat on a committee with the Department of Environmental Protection when they were reviewing the similar soils policy. What do you do when you dig out an environmental site and you have a pile of soil for reuse, that the soils don't have to go out to Maine to be disposed of at a huge cost? The reuse of the soil. So developing, just as a thumbnail illustration, to develop that regulation that would assist in those projects. So I sat on that committee that was developing the regulation that was ultimately promulgated by the Department of Environmental Protection. So again, we do that independent of the municipalities, but for the benefit of our municipal clients.
All right, thank you.
Yeah, Mr. Silverstein, I appreciate your comments on the fee structure and how you explain that, and it makes sense. And would it be something where if we took a flat fee type of structure and realized it didn't work out, and we saw the billable hours, that we could change the second year of that contract
Yes, 100%.
to an hourly rate? Okay,
Absolutely.
So there you go.
And just as an example, let's say you wanted to go with a flat fee and we negotiated what that flat fee was going to be. And you're getting the bills, you're going to see how many hours. And let's say our effective rate ended up being something ridiculous, like $300 an hour. We're not looking to take advantage of that and say, no, you have to keep paying us that the next year. So that would absolutely be on the table. And I guess, just really quickly, where we do have a flat fee, it's much less common for it to be an all-inclusive flat fee along the lines of what you currently have. It's more likely to be a flat fee for what are termed, regular town council functions. Town meeting, warrant review, contract review, opinion letters, that sort of thing, with litigation being outside it. That's more often what our municipalities that do want some sort of retainer, that's more often what it is. For instance, that's what it is in Sudbury, because litigation varies year to year. You don't necessarily want to be paying at this level where one year you might be here and one year you might be here. So that's just something else to consider. And as I said, no one goes into municipal law to get filthy rich. Obviously, we want
To get any kind of rich.
yeah. So we're happy to have the conversation with you. This is a town we want to work with, if only selfishly, because it's really close by to me and Mark. I'd much rather travel here than Provincetown, quite frankly. But
again,
it's a conversation.
Again, as I said earlier, it's a very sophisticated town. You have a number of fascinating issues, and so more than just the proximity and the selfishness,
Absolutely.
but it's the challenge of the town. We see each town presents its own challenges, and so we're very flexible in that discussion. Most of our clients don't have a contract for legal services, and the contracts are designed to protect you, not to protect us. We serve at the pleasure of our clients. It's not a situation where the client is bound to the contract and is bound for the year. So, as Jonathan was just saying, and as you, Mr. Chairman, are just alluding to, there's certainly flexibility even within the year. It's not a situation where you're bound to 2 years and then we'll look again. We reach a situation that works for the town. We work very hard to make sure that it accommodates the town because, again, we want to serve the towns. And we have kids we're sending to college. We have to make a living, but again, as we're saying, we're not looking to get rich. We're looking to provide efficient, effective legal services at a cost that you could afford, that you think is appropriate. And we're going to work with you to find that appropriate number. It's not going to be a number that we're going to force on you. It's a number that you're going to feel comfortable with. So if you're looking at the proposal and saying we're not comfortable with that number, that's a discussion point, and we're absolutely open to that discussion.
And Mr. Chairman, The ideal situation is we're not representing you for 2 years. So that only happens if you're happy with what you're paying for legal services and what you're getting back from us.
We're looking for the 10-year client, not the 2-year client.
Mr. Howard had some questions.
Yeah, a couple of questions. One, if I'd be interested in you speaking to, you talked about the training. Clearly, one area that is a potential cost driver is personnel. You talked about training with respect to the open meeting law and public records law, but can you talk about training that you may have done with regard to managing to the contract, FLSA, you know, some of the issues that our managers have to deal with, and how have you set that up, and what topics have you covered? How have you addressed those?
That falls into my wheelhouse. So it really runs the gamut of all of those. So we've provided trainings on sexual harassment and discrimination prevention, gender discrimination type prevention. I've done seminars on, you know, just basic disciplinary action. You know, one of the things that always comes up in my field is you get the call from the manager that says, you know, this employee's driving me crazy, they've done X, Y, and Z, it's been a problem for 5 years and I want to get rid of them. So the first thing you ask for is the documentation, and then of course, well, there's nothing in writing, it's been verbal. So essentially they're starting from scratch. So part of the goal with a training like that is to try to get your, you know, your department heads to understand the importance of documenting and staying on top of these things, because quite frankly, no good deed goes unpunished oftentimes in those situations. You know, so it's about educating so that when you get to a stage where you are getting to more serious disciplinary action, the type that tend to result in litigation, arbitrations, what have you, suspensions and terminations mostly, you know, that you're on a firm ground to, if they do go forward, that you're successful in those areas. Certainly FLSA issues do come up from time to time. It's a very complicated area of the law, particularly with municipal collective bargaining agreements, because they don't match up with what the law says, because the FLSA is a floor, not necessarily a ceiling. So it really runs any really particular area, and we tailor it to whatever it is that's going on in the town or whatever happens to be the particular issue. Conflict of interest, I mean, I understand people go through conflict of interest training, but when you have you know, new boards, periodically it's not a bad idea to do maybe sort of a mini seminar of the issues that when you have your volunteer boards, conflict of interest, open meeting law, you know, public records law, and kind of give them an overview of all of them. Collective bargaining, you know, making changes without providing the union with notice and opportunity to bargain. So those are all the types of areas that we can certainly work with the town and tailor it to whatever your particular needs are.
And just a comment, and perhaps I'd be interested in hearing your response. One of the reasons that we have maintained a level funded amount for legal services, obviously it has a measure of predictability. It's very predictable. But one of the things that I hear from some department heads, and I've experienced myself, is instances where individuals, whether it's it could be a Board of Appeals case or other individuals that want to pursue action against the town, view the particular decisions that may be made from the perspective, if we sue the town, they're not going to want to spend the additional money that it's going to take to address this issue. So in the case of a Board of Appeals matter, for example, whether it's a commercial industrial property, there are folks out there, and I'm sure you're aware of this, that go around and, you know, part of their gig is trying to identify clients, and they'll say, well, you know, I can cut your tax bill by, you know, $2 million or whatever. And the premise being that the town is not going to be inclined to spend the extra money to defend that case. So how do you, for the towns that you deal with that are paid on an hourly basis, that pay you on an hourly basis, how do you address that issue, or how do you suggest that they address those issues?
So depending on what the issue are, I mean, I can tell you from my own personal area where you end up, it does come up, say, for example, different contexts, but in the grievance process. Oftentimes, you'll have unions that will take the position that we're going to file a grievance on a 4-hour overtime because, you know, the town's not going to spend thousands of dollars and it's cheaper to pay employee X $150 for this overtime that ultimately they probably aren't entitled to, but playing the economics game, figuring the town's not going to go forward. So part of what the discussion I have with communities when those things come up is, you know, what is the likelihood that we're going to see repeats of this type of a thing? Because there are going to be times where resolving those cases makes sense. You're not going to just spend a lot of money for a small, you know, issue that is likely never to happen again. However, if it's something that's going to be repeating itself over and over, there are times where you have to take those cases forward just to send the message that we're not going to just pay them out. And oftentimes when you take that approach, it does change the response that you get going forward because the unions really don't necessarily want to spend thousands of dollars for a $150 case either. They're just playing a little game of chicken with you to see if you will. So that's my own personal experience in the area of law that I deal with where that comes up, and I assume it probably has some, you know, larger applications in their areas as well.
Yeah, I mean, I think it's always important to analyze each case and, you know, meet with the board in executive session. Obviously, the Board of Selectmen ultimately makes the call, regardless of what board and what decision is being addressed. The chief executive would be making the determination as to how to address litigation. It's important to analyze the case and determine the value of the case to the town and what the issue is. And you know, we talk about you know, principles cost money. If you want to stick to principles, it can be an expensive process. And depending on the town and depending on the principle, it's sometimes worthwhile. There are certain principles that you're not going to bend on. You're going to defend. You know, obviously, in the case of a permit denial, that's a situation where you're going to defend your permit denial. If it's a grant of a permit, you're going to let the permit holder defend its permit, and it's not so much of a town issue. In terms of enforcement, we have a number of communities that look to certain enforcement actions, and will spend quite a bit of money to enforce a matter to make sure that the principles of the town are defended. And we will analyze those issues very carefully. I think what we bring to the table is, again, the experience of having done so many of these cases, so we could assist with the analysis, but we could jump into the fray very, very effectively and efficiently. But ultimately, I think it's having the ability to analyze the case and present the pros and cons of the case, to meet with the board in executive session and determine the best route for the particular case. I don't think a cookie cutter approach is appropriate to any litigation, because every case is different. But if you're talking about things like, you know, if there are appellate tax board cases and individuals who are coming in who see you know, an opportunity to work with property owners to try to you know, appeal their classifications or what they're paying in taxes, and you're spending a lot of time at the appellate tax board. We have appellate tax board experts who are there all the time, and they work very closely with the ATB, and they know that process in and out, and they know how to obtain attorney's fees when appropriate. And very often we try very hard to get attorney's fees, and we try to analyze a case so that we can see if there's a mechanism to get a recovery for the town or get the attorney's fees, so that it's not an expense of the town. But I think it does come down very often to, you know, the case analysis and the determination of the board as to which of the principles that are inviolate that need to be defended.
And just really quickly, Jeff, the other side's spending money too. So if you spend money a couple times and you send the message, I mean, I have 3 young kids. They'll push my buttons a couple times and call me on it, and if I back down, I'm done. But if I stick to my guns and take away TV for a weekend, even though it hurts me, even though it's costing me more than money, then next time they're going to listen. And the word gets out there. So on balance, I find that if you're funding litigation at this level because you don't want to take the risk of it maybe going a little higher, then you're paying at that level even in the years when it probably wouldn't. So it's just something to bear in mind. And on balance, you have to just think about whether or not you need to do that. And as I said, one option, which might be the best of both worlds for the town, would be pay at an hourly rate with a not to exceed, so that the risk is entirely borne by us.
Have any
I
of
think,
you-
Jonathan,
Have you ever advised a board, committee, or municipality not to have council present for a board or committee meeting that was particularly controversial or anticipated to be particularly controversial?
I think that would be a rare situation. I think if there's a controversial issue, I mean, obviously.
That's when you want us there.
Yeah, that's generally when you want to make sure that the process is undertaken correctly, so that there are no flaws administratively, and that all the issues and all the considerations are given appropriate weight. And I think having council present is very important at the outset, because it's that initial phase that will determine what happens.
I understand the value. You guys have gone over, so I don't want you guys to you made your point. Thank you.
Yeah, I just wanted, if I can just briefly on that, the board drives, or whatever the board may be, whether or not we're there. So we're always going to advise you of the pros and cons of a particular situation, of the benefits of having us there or not having us there. Ultimately, it's your decision as to whether or not you have us there, though.
Thank you.
Okay. You all set for questions? Yes, sir. How about over here? All set for questions?
Oh, good.
I got to tell you that you certainly eased my concerns. I came in here saying, boy, it's a large firm. Will they show us, will they be attentive to our needs and what we are? And that comment, a small firm feel, and having three very top-notch attorneys certainly eases me quite a bit, so. Do you have any summary comments that you'd like to make before we conclude?
I think I agree. We've gone over, and I don't want to keep you any longer, but I think.
You used to charge an hour, so I get it.
No, we don't take advantage of that.
No, we'll stay as long as we have to.
No, I think just from our perspective, and picking up, Mr. Chairman, on what you just said, again, municipal law is based on relationship. We know that based upon the length of time we've served our clients. It's important that you feel like your counsel is your counsel. In the old days, and I remember when I was in the city of Everett, and we were two lawyers in that office, and we were in-house, and in the old days you had your in-house law department, and you had that go-to person. Municipal law has become much more complicated than that. I know what I did then, I don't do now. It's become that much more complicated. But you still want to have that feel of your local counsel. You want to think, this is my counsel, this is my person. You don't want to be thinking, this is my law firm. You want to think about the individuals and the faces. And while obviously as a law firm, we want to represent the town of Wilmington, as individuals, we want to be there for each of our clients. We want to be there for the town of Wilmington to be the people that you can count on, that you become comfortable with. When you talk to the clients that we work with, you'll discover that what we value is that relationship, the ability of our selectmen to call us up and say, I'm concerned about something. What do you think? And to have that conversation. And very often it's not on the clock, because we value the opportunity to speak with you. We're not looking at our watches every time you're talking to us. We have those conversations. We encourage our selectmen to call us and tell us what's on their minds, so we can get to know your community better from the inside, so that when we're actually appearing before you or appearing before your boards, we know what's on your mind, and we can address it on a personal level. We take it very personally. We want to make it a personal service. We're a service industry, and we want to make you feel comfortable with the people that you'll be using as your town council, so you feel confident that you can rely on those people. And we hope we're the ones that you'll be able to rely upon.
And then the only thing I would be remiss in not mentioning, Lauren Goldberg, our managing attorney, was with us when we met with the search committee, and she would have been here tonight, but she had an unexpected death in her family. So I just wanted to let you know that that's why she's not here.
Yeah.
And thank you so much for the time.
Yeah, I have to say, Joe is probably the smartest one, because you didn't tell us where you live. Now we know where they live, so we're gonna be on them all the time.
I live, well, yeah, that goes without saying.
No, you don't have to tell us, I was just, no, but thank you very much for coming.
Thank you for having us.
Thank you.
I just want to get my glasses. I
Yeah.
flipped them downstairs.
Yeah. Oh, no, that's fine. And we're back, and we're at our last interview with Murphy, Hesse, Toomey, and Lehane. Thank you all for being here at 9 o'clock, a late hour, I guess. So, let me introduce to you the members of the board. Mr. Greg Bendel,
Good evening.
Mike McCoy,
Hello.
Ed Loud, Jonathan Eaton, and our town manager, Jeff Holt. Thank you all for being here. And I'd like to, I guess, David, you're going to be the lead, so I'm going to ask you if you'd introduce your team and then give us some opening remarks, or everybody can give opening remarks if you choose.
Thank you, Mr. Chairman. My name is Attorney David DeLuca. I'm happy to be here, joined by my partner and colleague, Mike Maccaro, who will speak to the labor aspect of the proposal. I'm also joined by Cindy Amara, one of the veteran associates in the town council practice, and of course with Kathy Hesse, who will also speak to the labor portion of our practice. And again, we're very happy to be here. I think it's expressed at our initial meeting with your screening committee that we take a great deal of pride in the applications that we make. And quite frankly, we're very selective about those applications. We're not intending to carpet bomb the state with proposals. We look for what we consider to be a good match for our skill sets and with the communities that we represent. We represent only 11 communities. And in that, I think you'll find that there are several, at least 7 of those 11 are communities we've represented for 20 years or more. We also represent several communities in both the capacities as Labor Council and Town Council. And that is a significant and unique skill set, I think you'll find among the proposals that you're sorting through. We work hand in glove with those 2 practice areas. It is a fact that even though they may be defined as different practice areas, from the common experience of your board and town officials, there is a great deal of interplay. So we feel comfortable in being able to work in any town in both capacities. Now, as town council, as I said, we represent 11 different towns, and they are towns that really are very similar to the size and quality of the town of Wilmington. We are, counsel to the Board of Selectmen and available to all town officials on matters ranging from the public records, mass ethics, open meeting, procurement, land use, licensing, all of those details that, are day-to-day affairs of your Board of Selectmen and town officials. We also are available to clearly get quite involved in the town meeting process. We're going to be there for the development of that warrant, for the motions, for all of the parliamentary procedures that are followed through in your town meeting process. So we consider ourselves to be extremely competent, and I think you'll find also very, very available. We pride ourselves on our accessibility and our responsiveness. I can't imagine anything more frustrating for a town official or a member of the board to seek out counsel and be told that either not available or maybe, you'll get a reply some 24 hours later. That's too late. You're looking for immediate response, and from us, you'll get that. And as I said earlier, this is work that we're enthusiastic about. This is not a grind to us. I know that it's difficult for everybody to be here at 9 o'clock, but this is our standard operating procedure. There's nothing unusual about this for us at all. And I want to assure you that we go after it with all of that enthusiasm, and we will, I believe, make your board and the inhabitants of the town of Wilmington very, very proud of their town council. So with that by way of opening, I'll certainly let Mike speak to the labor practice, if that works, Mike, and certainly any questions you may have.
Sure. Good evening. Let me just say it's a pleasure to be here. I'll just touch briefly on the labor practice that our firm offers. With me tonight on that piece also is Catherine Hesse, who I know many of you probably know. She speaks around the state and to various boards on lots of topics that affect towns and boards of selectmen like yourself. One of the things that I believe that makes our firm unique from perhaps some of the other firms that you are considering is our history. We actually started off as a labor and employment firm, and that has been the hallmark of our firm going forward. We have a labor and employment practice as well as a town council practice, which Dave just spoke on, and the two of them really kind of mesh nicely together. I believe that Catherine was one of the original people who worked pretty quickly when 150E first came aboard, so you're looking at one of the people that started out right when it was there. That's how far back her experience goes. I know she doesn't want to hear that, but no.
Okay.
But I'm going to come back to that. But
years
I
after
want to, a couple of years after this, Arthur, but what you're looking at is you're looking at one of the premier labor attorneys in the state. She's won the prestigious Cushing-Gavin Awards. She is probably the foremost authority on employee benefits that you have here in the state. In terms of our practice, Catherine and I work with boards of selectmen and other public bodies, sort of splitting the labor all around the state. We work in Beverly together, Quincy together, Wakefield together, the Middlesex Retirement Board. So we've really kind of run the gamut of how we handle with our clients. We are familiar with any agency that you would ever have to go if you have a labor and employment matter, whether it be the Department of Labor Relations, Civil Service, mediators, you name it. There isn't a mediator or an arbitrator that we don't know or haven't worked before. There isn't a union, a state union that you have here that we probably haven't worked with and know all of the people together. So I think from that respect, I think the experience that we have in-house with our town council practice and our labor group, I think that really sort of sets us apart from maybe anyone else you have met with. The other thing is we have a big, and you might ask why am I telling you this, but we have a big private labor practice. And again, you're probably saying, look, we're a public body, why are you telling us about that? That's very important because whenever you're dealing with labor matters, you're dealing with your collective bargaining agreements. The people that govern that are your Department of Labor Relations here in Massachusetts. They take their lead from the NLRB. And if you don't know what's going on in the private sector, you can't really effectively do that in the public sector because the two kind of go hand in hand a little bit when it comes to language. So I point that out. I don't know, Catherine, if there's anything else that you'd like to add, we're happy to answer any questions that you may have, and look forward to addressing those concerns.
Attorney Ryan, you do most of the environmental litigation, correct?
I do a lot of environmental litigation too.
I know that you spoke to our screening committee about some of that. I was hoping that you could expound upon that for us.
Is there anything in particular you'd like me to
Well,
discuss?
I'm making the assumption that you've at least familiarized yourself a little bit with the Yolen situation that we have at Transrail. So I guess both your past experiences and any insight that you might have towards the Yolen site.
Well, I actually remember when the Olin site became a Superfund site a long time ago, and I was working at the Attorney General's office in the Environmental Protection Division doing hazardous waste under 21E. So that's the beginning of my background in hazardous waste, so it goes back quite a long time. And I've represented private parties and municipalities on all sides of environmental issues. I've worked with regulators from EPA, from the state. I've worked with private entities. I've been involved in government consent orders and in litigation and group discovery, motions, hearings. I've also had one of my favorite cases was a long time ago, bringing one of the first private rights of action under CERCLA for a water company whose wells have been polluted. So I've sort of done a lot of different things in environmental law, and we still have environmental issues that come up all the time that I deal with.
Okay, the second part of my question was any insight or that you have on the Olin situation that we currently have?
In terms of the cancer that it's causing to individuals and the fact that the wells...
Transrail.
I don't have too much specific knowledge on that. I do know that there are issues regarding some of the way the wells have been handled over time, and there are concerns from citizens and what you can do to protect the property and try to recover for some of the damages that it's caused the town.
Yeah.
I read in here that Ms. North specializes in environmental issues and 40B projects, but her expertise is environmental. So would she be someone that you would be working with?
We often work together on different environmental matters that come up, and we'll bounce ideas off of each other because we both have a pretty long background in terms of environmental litigation and environmental governmental actions. So we often will, and our offices are next door to each other, so we're always walking in and saying, what do you think about this?
I have also had some very recent experience with a very similar set of circumstances between the towns of Holbrook and Randolph. There's a proposal for a trash transfer station in Holbrook that Randolph is vigorously opposing. So, and I've went through 7 nights of hearing before the Board of Health in that matter. Now, in that case, I was defending the Board of Health, who had approved the project, but had some very direct involvement and insight into that dynamic. It may be a little bit different here, but I'm telling you, it was a worthwhile experience for sure.
Yeah, New England Transrail is trying to set up a shop, I guess, at the Olin Superfund site.
Yeah,
And it's
very similar in
serious
Holbrook.
issue.
It's, Transload America is looking to set up a transfer station on a damaged, environmentally damaged site there.
Yeah. Yep, Mr. Bendel?
Mr. Chairman, thank you. Good evening, and thank you for being here. My question tonight have been around land use, and so I wondered if, I know you have extensive detail here on page 2 of your proposal, but I wonder if you had a specific person here tonight, or if you wanted to describe how your firm handles. I could imagine in Wilmington in the future the possibility of some zoning issues coming up, and so certainly that would be important to us.
I read with some interest there was a list of the litigation cases that were existing. I guess it was about a year ago. And there were quite a number of land use cases that were before the land court. And that's, quite honestly, that's our bread and butter. I mean, we spend a lot of time with planning and zoning officials and working through that hearing process. And, certainly representing the town on those kinds of cases, both grants of relief and denials and requests for relief. So we spend, I personally spend at least a day a week at the land court on cases for our town clients. So there's nothing unusual there for us. Well, having said that, I mean, we're working with your boards, who are regular people just trying to do the right thing. So they come to us, we want to give them advice, help them navigate, and maybe in some instances be able to foresee and work around the potential litigation problems by getting advice in advance. There are cases where it's inevitable. Someone's going to be upset with the outcome, and there's going to be an appeal, and we'll handle that. But I do take a great deal of satisfaction in being able to provide day-to-day advice. We're very happy to attend those meetings and be able to guide officials in that process.
I would just like to add that I think I have a unique perspective a little bit too, because I've done a lot of land use and development work on both sides throughout my career. But for a period of time, I also was the director of planning in Dover. So I've also been very familiar with the planning board and what their rights and responsibilities are and how they handle cases. And a lot of my practice on a day-to-day basis, like David, is also handling ZBA litigation, keeping them out of litigation, giving advice as to what a building inspector can or cannot do, or what a planning board can or cannot do, or how they address a particular issue. And so those matters are, like David said, day-to-day for us.
Thank you. Thank you, Mr. Chairman.
Mr. McCoy.
Yeah, thank you, Mr. Chairman. Just a couple of quick questions. How many attorneys work for your law firm?
About 31 or 32 right now.
I just really like to ask, I know it's in here, and how many municipalities do you serve throughout the town?
Well, as I indicated, we represent 11 different, in the capacity as town council. We probably, as labor council, dozens more, right?
Oh,
Yeah.
yeah, a lot more than that.
Yeah.
So it's
I've personally worked with probably 35.
Yeah,
over
we
the years.
represent a lot of, on the labor side, and town council and labor is a little bit different sort of animals. We represent a lot of school committees as well. And on the school committee side, we do a lot of labor work there. We represent a lot of not only cities and towns, but also government agencies, sheriff's offices, retirement boards. We help them out on all of their labor matters. So I think we have perhaps one of the biggest labor practices in the state in terms of municipal.
No, I understand how many attorneys are here. I just like to ask,
Yeah.
you're right here, you're here at
Absolutely.
9 o'clock, so why not, right? And the other thing is, if you did get the job, do you think it would take just really 10 hours to have a transitional time? Is that all you think it would take? I know you need to meet other people in the town, but.
Whatever it takes.
Okay.
I mean, we're business people that, want to be able to make sure that, and it's a service business.
Yeah.
Our clients are our customers, and we're going to make sure that they're satisfied with the work product. And every town's a little bit different, and that transition may or may not go as smoothly within the 10-hour time frame, although our experience tells us, and we have stepped into many other towns in similar circumstances, that we make that work. So I'm not anticipating any trouble with that at all.
Can I just clarify that for it says here that it's 10 hours at no charge.
That's right.
But I'm sure there'll be a longer transition than 10 hours.
Yeah, but we're, as professionals, and that is, those that may be departing the client work and now stepping into the client, we're all very accustomed to doing that kind of handoff.
Because when I read that, and I understand you know the business better than I.
Right.
However, when you say 10 hours, and given, we're a little unique, we do have some serious situations here in town, Olin, New England, Transworld. We've had other things we discuss in executive session, which I can't discuss, that obviously would elevate that, but I just, like I said, you do this day in and day out. I just think 10 hours. I thought a little more than the 10 hours, if you get the job. That's all I'm saying, and I get that. And I understand you will have to meet, like, department heads and the manager and the assistant town manager, and I get that.
And I don't think anyone's sitting there saying, all right, we're at the 10 hours, so it's really,
No.
a lot of times we make these because we don't know all of the things that you discuss in executive
Yeah.
session. There's the stuff that we can find when we do our own due diligence, but I really won't know until we sit down and meet with you. And again, it turns out if you have a lot of litigation, it might be a little bit more.
Yeah.
If you have, a lot of labor matters that are ongoing, or a lot of labor unrest, that might require, Cindy and Dave to come out and talk to you about a couple set of matters, and maybe Catherine and I to come out and do
Sure.
that. So honestly, when we try to do that is we want to let you know that we want to come in and we want to learn about you and get a feel for that.
Very good. Thank you. Thanks. I'm good right now.
Anybody else?
Thank you, Mr. Chairman. I noticed in your proposal, you didn't come up with an alternate type of billing other than the hourly rate. The town's accustomed to a flat rate. Is that something you guys would be amenable to?
One of the
Kathy,
things-
speak to that.
Yeah, one of the things that we've done with some clients, it's very hard when you don't know a client, you haven't worked with them, and you know they've got a lot of litigation. And litigation is always the unknown. You know, just how many hours are you going to have to devote to this? And so it's a problem for you in that, you know, it looks like an open-ended chat book in a way, and it's a problem for us because it could bankrupt a firm if we misjudge it too badly. With very many clients. So what we have done that a lot of clients seem to like a lot is that we get an agreement from you. We usually would work with the town manager, administrator to, you know, to determine, you can see what you've spent over the last several years. You can see how many hours it's taken. You can judge, do you have a lot more litigation coming up or a lot less? Have you just settled half of your cases and all your contracts are settled, you know, for 3 years, or are you just entering into all of your contracts, so you're going to have some substantial labor fees, or, you know, where are you on these things? And you come up with what you think is a reasonable number of hours for us to spend, and we look at it, and you tell, you know, we basically have a discussion. Then we're able to come up with something that we would say, okay, here's our target retainer. And what we generally would do is we would then agree that we would come to an agreement on an amount. And I'm sorry, I don't have a figure because I just don't know enough about the specifics of what you've been doing. We would come to an agreement on a figure. And the way we've worked it with some clients is it's not a firm retainer, but what it is it's a target. We keep you posted. We can bill you if you want to be billed quarterly, if you'd rather be billed monthly. We can adjust to what your needs are that way. And then what we do is we do a true up each year, and we say, okay, gee, we spent 30% more time because you had so much more work than we anticipated, and here's why, so we're going to have to charge you. But what we have done in the past is we said, we won't charge you anything up to 10% overage. So unless we have to spend more than 10%, more than the agreed upon amount, we won't charge you for it. So, and unless your estimate is off that much, you're home free. You don't pay a penny more. If you pay less, then what we do, we can arrange for that to be a credit in the following year, or we can do a number of different things with it. So if you want us to look at something like that, if you could give us some firm data on, say, the last 3 years and whether you expect that to be more or less in the ballpark, we could give you a proposal on that.
All right, so we have a unique opportunity here for potentially new council, town council, and in my opinion, we have an opportunity to save the town money, and we've spent upwards of over $300,000 the last 3 years in town council, and we've got a lot going on. So did we get the big bang for the buck? I think we probably did the last 3 to 5 years, if whatever it was, but I know that the town manager and all the years I've been involved, because I was on the Board of Appeals in the past, we did have a flat fee. And in all three applicants that I mentioned, the one big if is the litigation. Mm-hmm. And that's agreeable. But what I don't want a ZBA member thinking, oh no, I better decide this way because I don't want the town to spend X amount of dollars litigating it. So I want that ZBA member to make the decision based on the merits and not what could happen. So I think that's one of the benefits of a flat fee, in my opinion. Like I said, I was on the ZBA for quite a few years, and that's where I'm coming from. Just so you know, that's how I feel.
Yeah, and absolutely. And we work with a number of communities who have that point of view, and that's why we've come up with this. And then if, you know, I think, you know, really for us, it's really knowing what level of service you're used to in demand, because it's actually, you'd be surprised how much it varies by community. Even if there's a lot going on, if you've got, you know, enough volunteer lawyers all over the place, they tend to do, you know, be doing some stuff, and they tend to, we are not called in quite as much as we otherwise would be. If we are, you know, and again, one of the things that we offer is things from, you'll go in and spend time with the people here, Dave, I know. That's part of your regular practice, but we will work with you on coming up with a fee that you think is fair and reasonable and predictable. Because I think you're exactly right. You don't want them to be afraid to call.
No,
And
not just the ZBA, but any town manager, any town, any manager in town, not the town manager, but
Yeah.
heads of departments. I just don't want that to be the way we rule, so that's why I personally am in favor of a flat fee. Now, I mentioned my zoning board, and I've asked the other two applicants this. The town of Wilmington in 2020 will probably be below the 10% for affordable housing. How experienced is your firm on 40B, and I think you mentioned earlier that you would recommend if there's a controversial or a potential 40B case coming in front of the ZBA, you would want to be there from the beginning at the meetings. So that being said, how well are you guys versed in that? And I'd like to know more.
I've actually done a fair amount of work on 40B cases in a lot of different communities, including in a community at a different firm where they also came below the 10%, and so they were in the position where they could selectively decide what 40Bs fit their community best. And we were able to work very closely with the ZBA and, quite honestly, with the 40B applicants to make them less hostile and to try to work cooperatively, because, I mean, as you know, the developer comes in and asking for the world, and the town wants as few as possible, and when you get past that initial view of the world and you start working together, it's very rewarding to see people actually come to grip with the real issues in a town that is actually striving to meet its affordable needs obligations.
Part two of that question is the town is looking at, the selectmen are looking at possibly putting a bylaw involving inclusionary. Have you guys done work with that? Have you helped with some of the towns you represent in inclusionary bylaws?
Yes.
What about the affordable part of it? The town is in desperate need of affordability. Are there ways that, as town council, you guys could help the town develop affordable housing, or bylaws or rules or regulations that we could somehow get more affordable housing in town?
Yes, I'm sure we can. I'm not quite sure I understand your question completely, though.
Can I just throw out a scenario? The town owns a piece of land and they want to develop it, but they don't want to be a landlord. So how do you go about doing that? Do you sell it to the developer at a cheap price, or do you lease it to them, or just throwing out a potential scenario that could happen in town?
Yeah, I've had some experience in at least one or more of the towns we represent where there are mechanisms where the public-private partnerships are developed, whereby if a town has available land, there are regional housing interests that will come on to that kind of situation. We'll, work with the town in developing a plan for affordable housing, whether the property is sold to that interest or there's some other kind of trust arrangement. That's something that we're very accustomed to. I know that it's an area where towns are getting more and more aggressive in being able to satisfy those interests. So I think, sure, we can certainly help facilitate that.
Last thing I have, Mr. Chairman. Olin and Transrail is a very important subject in this town, and it has been for many, many, many years. Can you expound a little better, if you guys know anything about what's going on there? Because it's important to all of us up here and out on TV land, what's going to happen in the future with Olin and Transrail. I would feel more comfortable if we had a town council that knows a lot about the NTSB and the federal government and Olin and the Superfund site, and just expand on your experience on that a little further if you could.
Well, as I said earlier, I've had direct experience with a nearly identical set of facts as between the towns of Holbrook and Randolph. And that is, a rail proposal that would service a transfer station that's located on a damaged site. So we've sort of handled that almost identical situation.
How did that, how
Well,
was that?
it hasn't finished yet.
Okay, right.
But the irony is, I was working the other side of the case, and that is that I was representing the town of Holbrook, who in fact had welcomed this site by way of town meeting vote and other actions of the town. So it was working with their Board of Health in their permitting of the site. So I've seen at both sides. That's why, in any legal case, sometimes the best advice you can get is someone who's on the other side of a case. They kind of know what's around the corner. So I do have some direct experience with that kind of case. Now, having said that, I don't know the details of the Olin site, but we will learn the details of the Olin site, I think, mighty quick. They do follow some patterns, and I know that Cindy has some knowledge already of that.
Yeah, and I worked a lot with different federal officials in EPA and a lot of different DEP officials. I've also worked for citizen groups trying to stop transfer stations like David. I've also worked with permitting transfer stations and worked with different towns and their concerns, and every single one is different, and it really is what the town's goal is, and whatever their goal is, I have no doubt that we have the knowledge base and the expertise to help you achieve that goal and to work with all of the parties to make it as painless, if possible, as it can be. And if it's a matter of how much you want to fight for a particular issue too, but our goal is always first to try to see what the goal is and accomplish it short of litigation, because in that type of situation, you're going to only spend more money before you get your result, and there's often less than litigation that can get you, if not where you want to be, close enough that it's a trade-off. So we're good at balancing those things out, and we're familiar with the players and the types of issues. And as David said, both sides of the fence. And that is helpful when you try to figure out why do they want this, or what do we have that can really stop them in their tracks, or what can we extract as a mitigation that might make it more palatable.
Thank you, Mr. Chairman.
If you could talk a bit about meeting the needs of Wilmington, your approach. In other words, is it a team approach? You have 31 other attorneys. You're going to you'll be the point person, and you'll have someone come with you, and it will be a team of 2 or 3, or will you have training for town officials or department heads? Will you be available? Will you be coming here? If you could just talk a bit.
Again, it depends on the needs of each client or municipality, but my practice has been to spend at least 1 day a month on site at Town Hall, and I arrange beforehand with administrative help from the Town Manager's office to set an agenda of town officials who wish to consult with Town Council at that particular day and time. And it's a full day, and it's a very productive day, in my opinion, because town officials can get real-time answers, or at least not answers. They can get some guidance, and from that we might have some takeaways and deliverables from a short time following that. It's an enormously beneficial experience for both town council and for town officials to be available like that. Beyond that, as I said at the outset, we're available 24/7. I mean, and that's really what we take a great deal of pride in. And in our responsiveness, you will not wait days or weeks for reply. It really probably would be a matter of minutes or hours at the most. That's really valuable, I think, to clients, to know that your matter is my only matter that day. I know it sounds silly, but you will know that in working with our office.
How many partners are there in your firm?
Pardon me?
How many partners are there in your firm?
About 12.
Yeah. I would guess.
About 20
We had
associates.
a couple retirements, but we also had a couple new
Yeah.
partners.
So about 20 associates, 12 partners.
Something like that.
Yeah. And we're very diverse as well. I mean, it's nearly 50-50 with men and women in our office. And we, just speaking to your earlier point, Mr. Chairman, yeah, we do a good deal of on-site education, or we've had opportunities to speak with town officials, or even your civilian officials, on things like public records, mass ethics, open meeting, you know, for an hour. We go through a slideshow of all of the high points in that, and we're happy to do that.
Do you have any case management software?
Case management?
Software.
Oh, sure. We have a DMS system that manages our, you know, all of our casework.
How much experience does your firm have in front of the appellate tax board?
That's your work, right?
I've done some work before
Yeah.
the appellate tax board, both here and at other places. Other partners in the firm and associates in the firm have also done litigation before the appellate tax board.
When you say here and other places, what do you mean?
I'm relatively new to this firm, but I'm not new to the practice of municipal law, and so representing towns previously, I've done a fair amount of appellate tax board for the towns of Sharon and some for Foxborough. And done some here in Natick. And
How many other attorneys in your firm have practiced in front of the appellate tax board?
I can think of at least three others. I don't know how
others.
many more.
Okay.
At least three others jump to mind.
Yeah.
Some of which are very experienced.
Yeah.
Mr. Chairman, I'm wondering if
Yes.
I could get back to Mr. Loud's question, because I think sometimes when I talk about a fee in generic, it's not as clear as if I use actual numbers that might put some meat on the bones. If that would be helpful, I'd be happy to give you an idea of how it would work. So let's say hypothetically, you look at the amount of work that you think you have to do, and we can either, we can exclude litigation entirely and just charge that on an hourly fee, or we could look at, and say, okay, here's the work that we would want to put on retainer. You estimate how much it would be. Let's say you look at it, you look at our hourly rate, you look at the amount of hours, and you say that's going to be $100,000 for the year, just hypothetically, because it's a round number and the math is easy. So what our proposal would mean is that unless you spend more than 10% more than the estimate, you would pay no more. The $100,000 is the cap. After that, you would pay hour for hour at our hourly rate. You would be billed on a monthly retainer, which would be 1/12 of that hourly rate. Let's say you don't spend it. Let's say you only spend 50% of it. You get a credit dollar for dollar. So basically, you're getting a 10% advantage on that. So what you would get is you would get then let's say you only spent $50,000 worth. Then you would have a credit of $50,000 that would be then applied monthly during the following year. We found that for the first couple of years, especially with clients who don't know us, we don't know them, it's a way to provide you a lot of security without jeopardizing us, and it really, it tends to work very well. But it's just an option.
Thank you.
So, just a question to that point, but in terms of the tracking, you would still provide the town with the actual hours that are
That's right.
being used, so that we could get a sense.
So that you can monitor and track it. And what you can do, particularly if you're on a arrangement like that, it's often advantageous for you to be billed on a monthly basis, because then oftentimes in some things, in some sorts of work, you know, you can push work off a little bit or bring it forward a little bit, be really aggressive and try to do as much as you can in one area, et cetera. So there are ways that you, knowing the rates, you can try to, you know, to manage that a little bit. So that would be up to you.
Mr. Chairman, I forgot one question. I asked the other two applicants, and it was about town warrant and around town warrants. And we have a lot of, in the last several town meetings that we've had the last several years, we've had what we call cleaning up or trying to clean up our bylaws, zoning bylaws. Would you advise the town on how to do that? Like last town meeting, we had a signed bylaw that we were presented that it was gonna be just cleaning it up and putting a lot of it together. They worked on it for many months and years, because when I was on the zoning board, we talked about fixing it. It's 3 or 4 pages in our zoning bylaw, and we're trying to clean it up. Would you guys be capable or able to help us advise the town how to make that, so next town meeting, we don't have to, we can present a decent warrant where it doesn't have to be tabled?
Yeah, sure, absolutely. I mean, that's a lot of what we do,
Yeah.
is making sure that articles are fair and square and legal. I mean, we've got to make sure that they're compliant with all other state laws, and that they work.
No, some of the ones that the town has brought in front of the townspeople have been pretty simple.
Yeah.
Missing a letter or some words and stuff like that. So that's the no-brainer stuff. But when it gets complicated like that, those are.
Well, and you're speaking of a town warrant article that's brought forward by the town, not a citizen petition, right?
Correct.
Okay.
Yeah,
So that usually is a different thing.
Yeah, and we had an hour-and-a-half debate on it, and then it ended up getting tabled, which
Yeah,
was
that's
rightfully so, because
Yeah.
a lot of people in town had a lot of great questions.
Yeah.
Often we'll work in advance, too, with the
Yeah.
planning board or the zoning board about the bylaw and what they want in it and what they're trying to accomplish, so we get to see it
Yeah.
in several iterations, particularly signed bylaws, in my experience, before it even gets to the warrant stage.
And I felt bad for our planning director, because she's only been in town for probably 4 or 5 years, and this goes way back. This bylaw goes probably 30, 40 years, and it's been added on and subtracted from over the years. So I felt bad for her that day. But that's just something that I wanted to know and have asked, because it's important, because that's not the only bylaw that we'll be probably changing in the next couple of years. There's probably others that we need to adjust.
One thing I would say is just because Cindy, you and I have done this in a couple of places very recently where she touched on working on the bylaws ahead of time with your people.
Yeah.
We might get it from the various board that wants to push something through. And we've helped them with that in advance, and sometimes they'll go through a number of iterations before you're ever getting to your town meeting. But what we also do, and what we found is, because I know Cindy just did it, is we can talk to the moderator. Sometimes having talked to the moderator, knowing what the warrant article is ahead of time.
And that's
to
a
be
meeting
able
that's
to-
ahead, in this town is held ahead of
Yeah.
time.
Yeah.
With the
Right.
town manager, I believe the chairman and the moderator and the town council.
So that is absolutely
That's
something that we do.
And it's a
on
very busy time of year
on
for
a daily
all you
basis
guys.
during those times of year.
Yeah, but
And
it's just important going forward, because I see a lot of growth in the town. I mentioned earlier, not necessarily 40B, but large developments that a lot of townspeople might not be in favor of, and stuff like that. So that's why I asked those questions. So thank you. Thank you, Mr. Chairman.
In litigation matters, it says here that you're generally staffed by 1 or 2 attorneys. Would you be the lead of that, or would would that be assigned to 1 or 2 attorneys, or one of you,
Well,
the lead
I know,
focus on it?
in my case, when it comes to the municipal litigation, I would like to, as always, bring on an associate assistant in any case like that. And we generally sign the pleadings together, both myself and the associate, but I consider myself the lead on that case. We're always conscious of making sure that we're bringing along associates, so I don't want to exclude an associate from the opportunity, for example, to argue a motion or something of that sort. But, if a matter is scheduled for trial, there's going to be 2 attorneys present, the lead counsel and associate counsel.
Is anybody else?
Just one question. Has your firm ever advised a board, committee, or municipality against having counsel present at a board or committee meeting when something particularly controversial was on the agenda?
I can honestly say, I've done both things. I've gone to boards and said, here's the advantages of having counsel there, and here's the disadvantages to not having us here. But there's also situations where if you want to be able to have a little more flexibility or wiggle room and not have to make a decision sometimes not having us there gives you the ability to gather the information, then come back to us. So I have actually counseled clients both ways on that one.
Okay.
Anybody else? I just, curiosity question, I guess. On one of these questions, it asks about municipalities that did not rejoin your firm, or, and it says not applicable, and I was just wondering why, and it asked the reasons why they didn't rejoin. I didn't know if there was a generic response why that wasn't.
I think I can answer that if I'm remembering the
Sure.
question. We've never had a circumstance where we've been let go. If that's I think the intent of the question. No, we've never separated from a municipality because of, reasons that might be mutually acceptable or for one reason or another. I know it happens, but like I said earlier, we've had clients municipal clients, I think 5 out of the 11 at least, for 20 years or more. There's a great deal of loyalty among our client base. So we've never, fortunately, never suffered that circumstance.
And that's why you put NA probably on
That's
that.
right.
So you should have
It's not
put,
applicable. It's not
never
applicable.
happened.
You've never lost a client in 20 years?
Pardon me?
You've never lost a client in 20 years?
I'm not a municipal client.
Sometimes clients come to you and hire you as special counsel. So you're hired to work on a particular case. So it doesn't necessarily mean that all the 100 or 200 clients that we might have worked with are still working with us on something, because maybe they just had a single matter that they had referred out. Is that perhaps that's what you're getting at?
No.
But once we're town council, I think what David said bears.
Thank you. You answered that fine for me. Any other questions on this side, over here? All right, I think we're all set. Thank you very much for coming at this late hour. It's very much appreciated.
Yeah, I'm glad to be here.
Thank you.
Thank you for having us. We really appreciate the opportunity to work with you.
Now, were you there as a trustee of the board, or?
Let's see how we do it. Highly unlikely.
Let's go, man. Let's do this.
Good night now.
Night. Okay, communications, we have none for this evening. Public comments? Ready? Yes, sir. Please identify yourself, your address.
Yeah, my name's Kevin McDonald, Wilmington resident. A few comments, but I just wanted to remind you guys that sometimes people that get voted into office forget that they actually represent the people and not the government. And when you're sitting up there, sometimes it's easy to forget, I suppose, that there are people in town that are affected by decisions. And we just had 3 law firms come in here to get interviewed. and you didn't allow any questions from the audience, which I suppose that's your legal prerogative, but it's unfortunate that you didn't do that. And I'm going to point out one particular situation before I make my other comments. The town of Wilmington has a high rate of cancer, and it would have been nice to be able to ask a question to the law firm because the Olin site seems to be the site that generates the most emotion on the board, as well it should be. And I'll speak in terms of allegations because I don't have any of the paperwork or documentation in front of me, but it's alleged that employees of Olin dumped chemicals into the lagoons at the Olin site, which were cancer-causing compounds. It created a plume that migrated into our well field, causing 5 wells to be shut down. Keep in mind what I said earlier, that Wilmington has a high rate of cancer. So these wells are shut down. And when an area that is used to having wells pumped are no longer being pumped, it's logical to assume that that groundwater is rising and the cancer-causing compound that is migrating in there is also rising with it and flowing to downstream communities. And I have a problem with that. I don't know if you guys have a problem with that. It's one thing to have your own community have a high rate of cancer, but when you know that something's going on or is potentially happening, and to not really be proactive in doing something about preventing that for downstream communities, I have a problem with that. And it would have been nice to ask the question to the law firms as to the ability for the town to put an injunction on that site to get sold on the grounds that it's a crime scene. And maybe not just an average crime scene, but a manslaughter crime scene if what happened there caused deaths and sicknesses and illnesses in town. And I believe you have some more interviews coming up. And I would hope that the board, if you want to talk about the Olin site, you bring this up to the other law firms. Because I think the town should be looking at ways to shut that site down from being transferred to the Transrail company. And I think it would be a possibility to shut it down based on having an injunction and calling it a crime scene so further investigation could be done. And one of the firms spoke about public-private partnerships. I believe he was talking about public-private partnerships with regard to housing, but it would be interesting to examine the potential of a public-private partnership where the town, along with the residents, are participating in a class action lawsuit against the companies that caused the cancer-causing compound to get into the well field and likely causing deaths in town. I see that you guys set agendas. I see the Boy Scouts, I see the Farmers Market, I see the hockey team, and I see other organizations coming here, which are fine organizations, but I don't really consider those issues to be of the tremendous magnitude as a community that has a high rate of cancer in this particular situation. The other issue that we have going on, we have people being taxed very, very high. And when people are forced out of town because they have fixed incomes, and I'm hearing $300 an hour for an attorney, and I'm seeing people being taxed on vacant land, undeveloped land that doesn't even have a building permit, being taxed more than somebody that has a house on their property, fully landscaped, I don't know if you guys have a problem with this, but you guys were voted in by the people of Wilmington that pay the taxes. And I would just like to have a question answered. Do you plan on doing anything to change the course, the way the town's going, and just taxing people and forcing them right out of this town? And do you have any plans on bringing forth agenda items, Mr. Carrick? Because I think you're the one who sets the agenda, if I'm not mistaken, with regard to an injunction on the property with regard to a possible crime scene.
Thank you for your public comment, Kevin. Okay, we're on to now important dates.
Mr. Carrick, that was a question. It wasn't
You had your 5 minutes. We're all set. I listened to your public comments, and thank you very much for those public comments. Important dates, Mr. Hull.
The first important date is the Shawshene Tech graduation, scheduled for June 7th. June 8th is the Rotary Trivia Night at the Knights of Columbus. June 9th is a brush drop-off Old Main Street, 9 a.m. to 4 p.m. Also, June 9th is a townwide yard sale, 8 a.m. to 2 p.m. June 9th is the town beach opening. June 10th, Farmers Market, Town Common Parking Lot, 10 a.m. to 1 p.m. June 10th, Brady's Foundation 5K Run for Recovery, Town Common, 9 a.m. June 11th, Board of Selectmen's meeting, room 9, 7 p.m. June 12th, Board of Selectmen's meeting, room 9, 6 p.m. Interviews for legal services. June 15th and 16th, the Wilmington Relay for Life. Wilmington High School starts Friday afternoon, runs through Saturday morning.
Okay, that's it. Is there a motion to adjourn?
So moved.
Second? All in favor? Opposed? Voted? Unanimous. Thank you. Good night.